Clear?
In loud and clear.
Okay.
Yep.
All right.
Sure.
Thank
We got you covered.
All right. Welcome, everyone, to this Tuesday, February 9th meeting of Money, Banking, and Trust. I'm your host, Christian Walters, and we'll get started. So I got the recorder going. Again, we're going to talk about NTT as new trust technology, and we're going through the Gilbert's Law Summaries book on trusts by Edward C. Halbach, Jr., and we're also looking at the treatise, the practical treatise of the Law of Trust by Frederick A. Lewin, 1888, two-volume series there. So that right there is a comparison of the black trust, say Gilbert's Law Summaries on Trust, and the white trust, the practical treatise on the Law of Trust, or public trust, the Gilbert's Trust, statutory trust, and versus the practical treatise on the Law of Trust, which would be the private trust. And then in 1933, everything did a divergence because we lost the lawful money, and the statutory trust came about, and we went on a parallel path. And everything has been run by trust, even though it may look like debtor-creditor, but really it's functioning as trust. So it's whether or not you see it or not as a trust, you really can't see it because it's really invisible. But what kind of relationship is being formed, whether it's a debtor-creditor relationship or whether it's a trust? And then people have to keep in mind that we're talking about statutory trust versus private trusts. And a lot of people are confusing what they think is a private trust, but they have nothing more than a statutory trust, which is operating in the public. And they think they have a private trust, and they do not. And most people today are using trust just for a protective asset device, and they probably have nothing more than just a statutory trust that looks invisible until the time where you get into trouble, and then that statutory trust is just as visible as everything else under debtor-creditor. And you usually get trampled on because it really wasn't a private trust. You were commingling your funds, and you really didn't realize it. And I see that there's some people out there that just do not understand, probably because they really haven't studied any of the trusts so much. If you go into the Gilbert's Law book, the Law Summaries book, and you can open up the first page, and it talks about trust by Edward C. Halbach, Jr., who is from the University of California, Berkeley, and he's also the reporter for the restatement on the third of trusts. And this Gilbert's is the 13th edition here. And then under that is the Gilbert's Law Summaries Board of Editors. Now, this reads like the book of who's who's of 28 professors of law, from professors of law, UCLA University, UC Berkeley, University of Texas, University of Stanford, UC Hastings, University of Texas, University of Michigan, University of Illinois, College of William and Mary, UC Hastings, Harvard University, George Washington University, Florida State University, Georgetown University, Duke University, Ohio State University, USC, and Pepperdine University. So it's quite a credential of the editors who are co-authors on this Gilbert's Law Summaries Trust. Quite a who's who. All these professors. So when we use the Gilbert's Law Summaries to back up our exclamations, our notice of interest, or whatever we want to say, the statement of interest being the actual law summaries, who is backed by all these who's, then I think it really packs some substantial facts, substantiated claims. And I think that is kind of like tying into the Bereans in the Bible, when Bereans, because they were the most noble that he had seen, because they listened to every word that Paul spoke, and he went back into the scriptures and checked out what he said as being true or not. So they went back into their facts, checked out the facts, and found out that the facts that he was talking about were true. So I think that some people, before they make some exclamations and remarks, maybe they should base it on not being slow to hear, but being, quick to speak before they start making some comments without checking out the facts. And they come to some conclusions based on maybe 10 minutes of listening to what we're talking about here, or maybe even if they listen to one whole segment, which may be, say, one whole session could be 2 to 3 hours long. I don't think from any one particular segment you might get what we're really talking about here is the application of trust, how it applies to everyday life, and trust being running everything. And even if your middle name is trustee, because maybe you have what you think is a private trust that you've been operating for, say, 10 or 15 years as an asset protection device, protecting the debtor, yourself, from the creditors attacking your assets. So I think you're quick to jump, quick to complain, and quick to point out, based on no facts and figures that you've checked out, substantiated out of Gilbert's Law or any other trust book. And I think you're very foolish to make any kind of claims based on that kind of judgment. Because I don't think you've really studied the trust and listened to what we've been talking about. That 900-pound gorilla. And I don't really believe that you understand debtor-creditor very well yourself, even though you may even have another complementary program on another network. But the real power comes into trust because it operates in equity. And if you've been listening to what we've been talking about equity, so if the beneficiary makes a prima facie case, and the burden of contradicting it or showing a defense will then shift to the trustee, and that's Bogart's 871 at 156 and 57, and see also Scott's on trust at section 172, and also again at 452 and 53, and also again under Bogart's under section 861 at number 2 and 3. And the burden of proof issue is one of the most significant distinctions and characteristics about the trust. And you might want to compare the case SNEP versus U.S., where SNEP had worked for the CIA representing the U.S. for years, and when he got the job and employment there, he signed an employment contract with them stating that he would never write a book without prior knowledge of and okayed by the CIA. And then when he quit 15 years later, they signed another contract to release stating the same thing. So the CIA had 2 signed contracts at which to come at him with if he breached that contract. But yet SNEP wrote a book that wasn't okayed by the CIA. And do you think that the U.S. or the CIA sued SNEP under double contract tort claim? For breach of contract? Nope. CIA came at SNAP under trust law. And I wonder why. Maybe they know something you don't. So that burden of proof issue is one of the most significant distinctions and characteristics about the trust. And there is no obvious transition from the threshold burden phase to the substantive burden phase. But where the party claiming the trust is the beneficiary, and what happens is what is referred to as a shift in the burden of proof. Thus, where it's the beneficiary is asserting the trust or claiming the trust, and the beneficiary is expected to make the party as the one who's filing the suit of the claim. And because the threshold burden of proof is on the beneficiary, who is the only one who can make the claim, then once the beneficiary satisfies that threshold burden, that prima facie case, the burden of proof shifts to the alleged trustee. And what does the trustee then have the burden to prove? Well, the trustee then has the burden of proof for non-breach, and he really has no evidence of that if he can't prove it. But the point to make here is about the evidence. Well, the beneficiary is the one who makes the prima facie case. Is that once that threshold burden is satisfied, the law of trust presumes that the trustee is wrong or is guilty, period, or has breached the trust agreement. And the trustee must prove that what he did was consistent with applicable trust agreement. That will, that intent by the grantor, one of the first two elements of the four elements of formation of the trust, and with applicable trust law. So thus, in the civil or the commercial context, a trustee is quite literally presumed guilty or presumed to have breached already. And he hasn't even gotten into the case yet. So he's presumed to have breached, as it were, and he must prove that he was within the terms of the trust and within the applicable trust law, that is, not guilty. And he can't do that without proof of a performance. And he won't have that proof unless he did. So to review this in context, which we'll find ourselves regarding these government-sponsored scams, the threshold burden is on the beneficiary. So that party must prove up the case of the beneficiary, the trustee, and the trust res. And then after that, and only after that, the threshold burden is satisfied and the burden of proof shifts to the alleged trustee, who must then show compliance as a non-breach. So let's look at it another way. While it's an indisputable fact that the trustee carries the burden to show compliance with the trust agreement, it's just as indispensable that such a burden doesn't even exist until after the beneficiary carries the threshold burden to show, number one, that the claimant is the beneficiary and of the trust with the trust res, number two, and three, managed by the alleged trustee, which points to the maximum: he who claims trust must prove trust before the burden shifts. So if there's any lack of any presumption where the trustee, where the grant of power to, say, pay a substitute, the trustee may pay the funds to any alleged successor of an absentee or a beneficiary at his peril, or hold them indefinitely until he can secure protection by the court order. So this is known as the unknown beneficiary problem as a defense, where the alleged beneficiary is unknown, then the alleged fiduciary has no duty or obligation to such a party to pay. But if that beneficiary is there, and it's been identified, and that beneficiary knows there's a trust, then everything else changes. So the fact that we say that no party needs to know or understand they are forming a trust, now it's the grantor, the trustee, or the beneficiary, and because you say that's impossible, well, I suppose you know so much that you know everything. Usually those fools do. But if you go by the little example that I give, and maybe you just didn't catch it on one tape series, but I throw it in there occasionally, and we go over it. If I give you my pen, and I say I want my pen back, you may never known that we formed a trust. In fact, nobody may never have known that we formed a trust. But you see, nobody needs to know or understand that a trust is being formed, and the key operative word here is being formed. But once a trust is formed, to come upon the beneficiary to enforce that, he would have to know and understand. Now, I didn't say that the party all the parties need to know is in order to enforce. No, I said no party needs to know or understand they are forming a trust. I didn't say enforcing a trust. And I pointed out the facts that substantiate that under Sections 23 of the Restatements of the Second on the Law on Trust, and in the Gilbert Summary Law on Trust, page 19, Section 67. But if you're so quick to judge without listening to some back tapes, without coming up with some substantive cross-claims, then you have a conclusory pleading, and your claims are unsubstantiated. And you fail to state a claim upon which relief can be granted. And you don't have a claim. But did you check out the facts? That no party needs to know or understand that a trust is being formed? Or are you quick to judge and just say, oh, I don't believe that? But the fact that when I gave you my pen, I said I wanted my pen back, there was a trust formed there because all the four elements are necessary, which I don't even think you even understand. Plus one of the four methods of formation was there, and the law must recognize that a trust was formed. Now, if I want to enforce a trust, I'm going to have to know that a trust exists, which is a different set of circumstances from formation of a trust. Because it's very easy to form a trust without any party in the trust knowing that a trust was formed. Because I might not have known as the grantor that giving you my pen and asking for it specifically back, you didn't even realize that you were the trustee. I didn't realize I was the grantor. And I didn't realize that I was the beneficiary of that when I said I wanted it back. And when I said I wanted it back, you didn't realize and I didn't realize that what I was really saying was that my specific pen could not be commingled with the other funds because how else could you give it back to me? So you had to have segregated my pen, and that's one of the key operative words in a trust. But yet you're quick to judge because you know it all. But without checking out the restatements of Second and other passages in Gilbert's and other trusts, page 19, section 67 in Gilbert's, so I don't like it when people take and start nations and quick to judge, and they're not checking out the facts. Based on 10 minutes or maybe one whole sessions of listening to some recording and then call somebody a fool and say that they must be, I don't believe them. I think you're the bigger fool myself. So in defense of myself, I'm going back over that and asking you to check out those facts. But I don't suppose you're on this call anyway because you think that everything we're talking about is a bunch of hooey. But just for the record, I'm putting this out there. So in case you ever do get it or hear it about the roundabout way, Mr. Trustee, Section 67 on page 19, Gilbert's Law Summaries. Number 2, Section 66, we'll start there. Form of expression. There must be some external manifestation of intention by words or by conduct. 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 And let me say that conduct is an action. And your silence is an action. It is not enough that the settler's intent was formed in her own mind if she gave no external manifestation thereof, nor are vague expressions of donative intent sufficient. The settler must manifest a specific intent to create. I want my pen back. As to some particular property, my pen, in a relationship known in the law as a trust. A, Section 67, wording. No particular words are required. No particular words are required. The term trust not be used. Nor is it essential that the settler or any of the other parties involved know or understand that the intended relationship is a trust. Would you like me to read that again to you? Take the earwax out of your ears. No particular words are required. The terms trust need not be used, nor is it essential that the settler or any of the other parties involved know and that the intended relationship is a trust. If the court finds that the parties intended to form a certain relationship with respect to the property involved, if the law defines the relationship as a trust, then the party's intention to enter into a relationship provides the requisite trust intent. I want my pen back. All the requisite elements of the formation of the trust and the intent are there, and nobody knew anything about it. It was formed, and the law must recognize it as a trust. 1, under Section 68, the parties may refer to their relationship as a trust. If the requisite intentions are lacking or the essential element is missing and not to be provided by a court, then there is no trust. But if you wanted to enforce the trust, how else would you enforce it unless you knew there was a trust? Because you would be probably coming back under somebody under debtor-creditor instead of trust. Exactly what's happening today, how you're being duped and scammed into believing it's all about debtor-creditor when it has nothing to do with debtor-creditor. It's all about trust. (69) If the parties proclaim their intention to create a bailment, agency, or guardianship or other relationship, the court may find the real intent was to create a trust. But what if you never knew it was debtor-creditor relationship? How about that one? So he makes no statement that no party in the trust needs to know or that a trust is created. Not the creator, trustee, or the beneficiary. So where is it written that when people are duped, defrauded, or lied to, that they then do so valid? That's nonsense, he writes. Then he says he can make a claim that the trustee need not make a payment. But where is it written that the trust document who the trustee is and he is required to make a payment to the beneficiary? There has to be a trust document someplace. Oh, yeah? What about an oral trust? What does oral mean? Is there anything in writing in an oral trust? I'm asking this guy, where's your brains at, buddy? There has to be a trust document somewhere, he writes, and not all trusts require the trustee to make any payments to the beneficiary. He says, I have created such trusts before where the beneficiary has no say in how the trust is operated, and there's no requirement that the trustee ever pays the beneficiary. This is called a pure trust. So where is his documentation, he says? How in the world can you be the grantor, we like to use creator, by the way, he says, of the trust without knowing it? The grantor wrote the trust document, and how can you write it without knowing it? Well, I don't think you're thinking very clearly, or whether you're thinking at all, Mr. So-and-so trustee. He says, I've been living in a trust for about 12 years now, and what I've learned, Christian is learning and misapplying. Well, I just gave you the facts. And if you don't check out the facts, I think you're a fool, according to Proverbs 18, buddy. He says, I see nothing new and very little that is valid. And Christian used to call on our show on Friday as he plugged his show on Saturday. He's a nice guy, but this is not the way to go, he writes. Well, I think you better check it out further, or you may be doing yourself a great injustice. And I'm pointing this out to you as of Matthew 18, so that you can correct your ways, because maybe we might be onto something. Because I think this blows debtor creditor right out of the water. I think a few other people see the same thing. Although they've taken a little more time to study, and they checked out the facts, and those that are still here, I commend them, as Paul commended the Bereans. And without mentioning any names like J.C. or Eric or Rhonda, and some of you others out there, you're the ones that I commend. Because you didn't just take what I had to say, you got the book. And you studied the book. Unlike this fellow who was quick to judge and didn't check out any facts. So you out there, Mr. Trustee, you know who you are, and so I hope that you get this sooner or later. But please don't take this the wrong way. But I think you need to take more stock in checking things out, because I'm afraid you're going to cut your nose off to spite your face. So I hope this brash talk doesn't tee you off, but I don't give a slack. So in defense of myself, I say these things. So we must have the four elements necessary in that trust to form that trust, that intent and that purpose, and those parties in that specific trust res. And the intent and the purpose, well, that's just more or less the will of the grantor, and you can't have an oral trust without it being in writing. Unless you have under statutory law, a statutory trust, where this law, the statutes of frauds comes in, pertaining to real estate. But pertaining to property, you certainly can't have one under the statutory world, an oral trust. And the formation of the trust by words, and words is defined in Gilbert's as being written or oral. Written or oral. Or conduct. And remember, conduct can be your silence as an act. As long as we got one of the methods of formation now of a trust, which is one by declaration, which are words or conduct, and two by transfer, and 3 by appointment, and 4 by contract, in forming a trust in the future. And then we have number 2, transfer, which breaks down into 3 subgroups, which is you won't find in some of the books, but it's there, which is endorsement, which is a signature, and B, delivery in bearer form, and C, assignment, and that would be on a UCC 3, and D, by operation of law. So see, we're only talking about 11 things here, very simple things, 4 elements, and then we have the 7 different methods of formation, really, which boil down to just 4 main ones with the subgroups. But then again, no party in the trust needs to know or understand they are forming a trust. Forming a trust. Didn't say enforcement of a trust or duties of the trust. Although even duties, because you didn't know you were the trustee when I wanted my pen back, and really the trustee in charge of my pen held in special deposit as long as you're holding my pen. But if you don't give me my pen back, you've created a breach of trust, and how would I know it was a breach of trust? Because at that point, in order to force it as a trust, I'd have to know it was a trust. And I would have to have the necessary elements and the method of formation, and I created a record of that the court could see, and then I could prove that trust. And once I proved that trust, you as Mr. Trustee, you're a big doo-doo, because you're the one that's presumed guilty in a breach of trust, and the only way you can prove that you didn't breach a trust is whether you got a record that you gave me my pen back. And it had to be the same pen that I gave you, because I said I wanted my pen back. That was a special deposit. Trust distinguished from similar relationships. Those characteristics, not terminology, are controlling. Section 27, Gilbert's Law Summaries. It says, similar array of rights and responsibilities, including fiduciary duties and obligations, may be found in a variety of other relationships that are, in varying degrees, somewhat similar to trust, but they lack one or more elements of a trust. And it is often very difficult to ascertain whether the parties involved intended to create a relationship that is recognized in the law as a trust, because the use or the failure to use trust terminology is not conclusive of the party's intent. I want to read that again. Because the use or the failure to use trust terminology is not conclusive of the party's intent. And see generally the restatement on the 3rd, section 5. That's on page 7 of Gilbert's Law Summary, section 27. Two, bailment, section 28. Talks about bailment and the guide for distinguishing. Then it goes into the principal differences between bailment and trusts. So there's one similar relationship. And then it goes into agency. Talks about agency on page 8 under section 35. Then it comes into the big one I like to pick on all the time, which is on page 9, which is the debtor-creditor relationship, section 42. And also the guide for distinguishing under section 43. And they give the example here of a transferor who hands the transferee a bundle of $20 bills totaling $500. And it indicates that she wants the money returned at a specific date. And if, as is likely, the transferor does not care does not care whether she gets back that particular group of bills, in other words, specific property, or even property directly traceable to them. The arrangement cannot be a trust, but as a simple debt, and thus the transferee can, or any $500, and is free to dispose of the particular bills received. But if I would have said I wanted my specific $20 bills back, the exact same ones that I gave you, I want my $20 bills back, you have a trust. Because all the necessary elements are there, and the method of formation is there. Then it goes in some of the other relationships, the equitable charge, which I'm not going to go into. The fiduciary duties and things, and the conditional fee, and on. But I think the point has been made. But remember that no particular words are required, and the term trust need not be used, nor is it essential that the settlor or any other party involved know or understand that the intended relationship is a trust. Section 67, Gilbert's Law Summaries. Again, written by 28 professors of law that read like a book of who's who across this country of the top people in trust involved today. And the main man, Edward C. Halbach, Jr., who is the reporter for the restatement of the Third of Trusts. So if you tell me that I don't know what I'm talking about, you're saying these 29 people don't. So I like to liken it to the special deposit here, the specific trust res. That is the trust deposit or the special deposit. And everything that comes in your mailbox or an indictment or whatever it is in the mail is really functioning as a trust, and we need to treat it all like a trust. In order to treat it like a trust, we have to know how to recognize a trust, how to take that offer, which is free. The offer is free for the opportunity for the obligation under debtor-creditor, how to take that free offer for the obligation and turn it into a trust, which it is. It's going to be enforced as a trust. And you're thinking of me coming at you under debtor-creditor, and they're really not. Because they're getting you in equity to foreclose on you, to arrest you. And the court of equity was what they used to get you. But if I take that offer for debtor-creditor, and I turn around and I express it being a trust and give it back to you on a transfer, so what you gave me was the title to the debt, and what I give you back in return is the title to the asset under special deposit. And what I gave you also was a order to merge the titles, because you're standing there holding as trustee to the debt, which is the legal title that you tried to give me, and you're getting back the title to the asset, which is the beneficial title, and I'm giving it back to you and merging it all in one entity as you missed being the trustee, and now the trust is terminated, and that special deposit cancels out the debt. That trust asset, that title to the asset, the equitable asset, cancels the title to the debt. the offer for the debtor-creditor relationship. But I expressed it as a trust, and I didn't take your offer. I turned it into a trust, which it was a trust all along. I just expressed it to being a trust. Equitable assets, fourth revised. It says equitable assets are all assets which are chargeable with the payment of debts or legacies in equity, and which do not fall under the description of legal assets. Legal assets. They don't fall under that description. Legal assets are public side assets. Continuing on, those portions of the property by which the ordinary rules of law are exempt from debts, but which the testator, that would be the grantor, has voluntarily charged as assets. In other words, I'm using this as an asset. Period. Or which, being non-existent at law, at law is public, is the same as legal assets. That's public side. Being non-existent at law, have been created in equity. Different side. Equities, the private side, excuse me. Equity is the private side, and equity was where courts express their conscience through trusts. They are also called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule from that which governs the distribution of legal assets. There is a fine definition comparison of versus public.
Where are you reading right now from, Christian?
Black's Law, 4th edition, revised, under the definition equitable asset. It says on the 4th edition revised, it says an equitable asset or all assets which are chargeable with the payment of debts or legacies in equity, and which do not fall under the description of legal assets. Those portions of the property which by the ordinary rules of law are exempt from debts, but which the testator, the grantor, has voluntarily charged as assets, or which being non-existent at law, have been created in equity. And he's quoting from Adams, Esquire, 254, at Sequita. Continuing, they say they are also called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule which governs the distribution of legal assets. And there's an abbreviation, second, FONBL, I don't know what that stands for, EQ, Equitable B4, Part 2, C, Section number 1, and notes. And also under Story, Equity, Section Juris 552. You know, I think I do a very thorough job of backing up just about everything that I say with specific material facts that anybody listening to this program verify. If you don't, well, that's your own choice. But I don't expect somebody to come criticizing me without first checking out the facts. And don't just listen to one show or a download and think you know it all. Or think that you're even on the same page as those who are here listening to this call for a while. Even if you've been in trustee for a trust for 15 years on a debtor-creditor relationship as an asset protection device. Because I'm not using trust as an asset protection device. I bet you didn't know that.
I just want to come right back real quick. You said equitable asset in Black's Fourth, right?
Yes, revised.
Revised. Okay, because it's not popping up on that one I got here.
Yeah, equitable asset is only in the revised edition in that one.
Okay. That's an excellent definition, and it's interesting because it's not showing up in the fifth.
Yeah, I pulled it out of another one here I had also. I think it was in the sixth also. I think it read exactly the same in the sixth.
I got the fourth, fifth, and eighth. Take a look in the eighth here. Thank you.
But I liken that special deposit in the acceptance of the offer, so to speak, although I don't like to use the acceptance, really, because I don't want to give any credence to any acceptance coming under debtor-creditor, so I don't like to really use it so much. But really, if I put my signature on it, that is kind of an acceptance, but really it's an expression of the trust, which is the rule of signatures. And if I return that back to that person as a special deposit, what I've really done is I've just created two titles, or brought into existence into the public notification world by notification, that those two titles exist. The title to the debt that you gave me as the offer, and the title as the asset that I gave you back as the special deposit. And the title for the debt and the title for the asset are now merged in one entity, and both those titles cancel each other out. And what I've done really was an order to merge the titles. And it was the actual order, the merging of the titles, which I liken it to a bill of exchange, which actually is the payment. It's not that the merging of the title order is a BOE or a check or a draft. No. It's just an order to merge the title. But that order to merge the title is the payment, because that's what merged the two asset side with the debt side, and it canceled each other's out. Welcome to the world of trust.
So it's Christian.
Yeah, go ahead. Go ahead, Rhonda.
Yeah, this is Rhonda. So if I hear you right, what you just said there was, because I think when people think two titles, okay, there's, two separate things. Actually, what I just heard you say is they're sending you, the title they're sending you is a debt title, and by you signing it and sending it back, that same piece of paper,
turn it into a special deposit.
Turn it into an asset title.
Yes.
It's the same piece of paper.
Yes. It turned it into an equitable asset. It was an offer for a debt contract that I turned into a trust, although it was a trust all along. If I didn't express it to be a trust, it would be construed under debtor-creditor, and only the debt title would come forward. But since I expressed it as a trust, now the debt asset comes forward, and when the debt asset meets the title to the debt, the two cancel each other out in a merger of titles. And it's a payment. It's a trust receipt. And a trust receipt, everybody knows a receipt is a record of a payment. Black's Law 8 defines receipt to acknowledge the receipt of something, especially money, and two, to give a receipt for something, especially money. An example, the bookkeeper receipted the payments. That was a payment. And then Black's Law 8th edition again, trust receipt. A pre-UCC security device, now governed by Article 9 of the Code, consisting of a receipt stating that the wholesale buyer has possession of the goods for the benefit of the financier. And today there must usually be a security agreement coupled with a filed financing statement. Well, that UCC filing is my trust receipt.
The record that you got it and the record that you transferred it back to him.
Yeah. When I put it on a UCC3 transfer statement, that's my record as a trust receipt, a record of a payment.
That was just the first time that I heard you, that it clicked for me that one piece of paper was both titles.
Yes. The offer you gave me was the title to the debt, but the paper I gave you back, the same paper, was changed into the title to the asset. And I merged the two in one entity, the trustee. And will combine with the formation of a UCC3 method of formation as a transfer. As long as I got one of the four elements necessary, the intent, purpose, parties, and specific trust res, which is the trust deposit, the special deposit, then we had a trust that was terminated as a payment. Now let me read you trust deposit. Black's Law, 4th Revised, where money or property is deposited intact and not commingled with other funds or property of a bank, and to be returned in kind to depositor or devoted to a particular purpose. Remember, what is purpose? Purpose is one of the four elements of a trust. Devoted to a particular purpose or requirement of depositor, or payment of a particular debt or obligation of depositor, also called special deposit. What did I do when I paid the payment with a special deposit? I made a trust deposit by special deposit. It got paid because it was for the purpose of the depositor, the requirement of the depositor, or a payment of particular debt or obligation of the depositor. Who was the depositor? The grantor. Who was the one who gave me the offer? The trustee. Who's got the titles now? The trustee. Trust was terminated by order of merger.
Well, until we get that IMF file straightened out, really they're construing it to them being the beneficiary, right?
Yeah, they like to see that we're the trustee and they're the beneficiary.
So they're sending us as a beneficiary, they're sending us a bill for payment, and we're going to turn that into an asset and merge it back and turn it into a trust, actually, and send it back to them. We can prove that we made a payment by the receipt, the record of the receipt of the payment. If we get an offer from them, you said something about signing it. Should we sign it? Should they send us an offer, or should you just put a memorandum with it, or with an order to do certain things?
I might run across it a diagonal 45 degrees right across the face of it, say in red pen or something, by, in a specific signature qualifier.
Okay. For settlement or something like that.
I really don't even have to do that. I mean, who is going to get me off track to confuse me about my intent and purpose? Only myself. Okay,
and that could be your intent and purpose is going to be on the order of what they can do with that title.
Yeah, because the definition of trust deposit said it was specific purpose and intent that this deposit is being made, and they gave several different options there. So for debt or an obligation, or devoted to a particular purpose.
Just sign it across the title by grantor so-and-so, and then put your order with it and turn it into a trust.
Yeah, because the trust could be oral. There could be parole evidence admissible in court, which is verbal evidence. As long as the grantor is still alive, he can come back in and express his intent and purpose because he's still alive. The only problem is when that grantor is dead, he can't express it unless it's in writing. Unless his will is put down on a piece of paper through the expression of the indenture, if he's dead, that's the only way you're going to really prove his intent and purpose. If there was specific wording, then if he was dead, then the courts could construe it otherwise. But if that grantor is still alive, he can still come back in and express his intent and purpose and correct any misconstruement that the courts could be construing it under. And the one we used in before in the cases was stating that there were 3 case sites that we gave an expression of the trust that basically said the grantor is the law of the trust, whatever his intent and purpose was.
Mr. Walters,
Yes,
question for you.
Question?
Yeah, who's this?
Yeah, this
Go
is
ahead.
Bill from New Jersey, Christian.
Yeah, yes, go ahead.
Yes. Now, if I understand you correct, let's say if we're the trustee of the Social Security trust, and the beneficiary sends us a bill, and now at that point they transferred the equitable title to us as trustee. Is that correct?
Are you saying on a Social Security?
In other words, like we're the trustee in the Social Security, right? Or is that correct?
No, I believe it's the other way around. We're really going to have ourselves as beneficiary because we're carrying the little beneficiary card.
Okay, which account are we trustees on?
All right. I think we're trustees on all the trusts except for the Social Security. But see, that's in opposition to the master file, and the master file is the one all the other agencies got to comport to that master file, while being in the IRS.
So
By
the
a
master file
1040 form, we've actually self-declared ourselves under declaration of formation of a trust to be our status to be trustee.
Right. So now,
on the Security, the Steady Key Trust, we're actually got the beneficiary card and we're receiving benefits from that trust. So that's like an opposition. Excuse me. If the individual master file in the IRS, if that record, and we have that established that we're trustee, all the other agencies got to comport to that. That means Social Security has to comport to that also. But now you see that's in a conflict. That creates a conflict. So there's a controversy there. So that's how I think that they're getting you to be incompetent and taking over your assets and managing it for you because obviously you don't know what you're doing as trust administrator, trustee. You've got things mixed up.
right. Let's say in a commercial transaction, we receive something in the mail, and you should say that's an offer, and we then assume we owe trustee. Is that correct?
Or we receive an offer in the mail, you say commercial transaction.
Yeah, there was a bill, and
Okay.
so they send it to us. Now we are the trustee. They assume that we're the trustee. Is that correct?
Yeah, we're assumed to be the trustee, yeah, because the IRMF master file has got us down as trustee. We've self-assessed ourselves trustee, yeah. So they're giving the bill, the offer, to the trustee, according to what it says.
Right. So at that time,
But that's an offer to take and go under a contract under debtor creditor.
right. We could
Just an
take
offer.
that. We could take that title, right, and then we can terminate it under our jurisdiction as a trustee. Can we?
Yeah. But now we want to change our position from being trustee and say, I want to give it back to the trustee. And really, they're going to be the trustee.
We're going to sign them as the new trustees.
Yeah, I'm going to come in and prove myself to be grantor so I can come in and say, hey, there's been a misconstruement here. You guys are all doing it wrong here. I'm not the trustee. I'm the grantor. And if I'm the grantor, I'm the one who gets to define parties. And I'm defining the party because you guys misconstrued it, and I'm making you trustee. And I'm going to, which is my special deposit, I give it back to the new trustee now, the one who gave me the offer in the first place. But now I've corrected the misconstruement and given the trust res property, the trust asset, the equitable asset, to the correct trustee this time. An offer for an asset, so to speak. And when the two offer one entity, they cancel each other out under whatever your order.
One party, either trustee or beneficiary, the trust is terminated.
Correct. But I
right. So then, are both titles in our possession as trustees?
No, they're in the new trustee's possession. The one who gave me the offer in the first place.
Right, I understand that through transfer or assignment. My question is, can we as trustees have the same ability?
All right, you're talking about yourself as being the trustee.
Yes.
Yeah, under the master file, you're still probably trustee until you correct that master file.
Is that the case? What I'm understanding is, if we transfer it over the bill to the guy who sent it to us and make them trustee, that have both titles, the trust is terminated. Send it to us, and we're trustee. Do we have both titles? If we do, then we could terminate the trust.
Yeah, but how are you going to prove it a merger? Did you send the offer to them, which was the equitable title?
Oh, no.
Any documentation to prove that?
Oh, I see. Okay, so I would have to have documentation to support that.
Yes, yeah. You got to have a material fact to support your claim.
If I did have documentation, then I could terminate the trust as trustee.
Yeah, but I don't think there's a way to get the documentation, so that's why we're appointing a new trustee and creating documentation or records to prove that I transferred it to the new trustee, which proves that I merged titles.
Okay, I got it. Cool, thank you.
Christian?
Yeah.
This is Michael. You were just talking, and something just popped into my head. What's interesting is, once we do the WH and we correct the IMF file, what's to say that we don't get offers in the mail that the file's been corrected, and all these credit card people see that all we have to do is tell them to go in and clear out the account if it's a credit card. I think once we do the W8, we're going to see some doors open up for us. You follow?
Kind of, yeah, but I don't think I'm following clear.
Well, once the W8 is filled out, and then these credit card people are going to realize that we're a different status. In other words, and we have the authority to tell them to go in and make settlements on a monthly basis on a credit card. I just think we're going to get new offers.
A lot. I see what you mean. Yeah, because you're guaranteed payment.
Yeah, that's what I'm saying. Yeah, it sounds real interesting. And I have to come to you. I'm glad that you said in regards to your email letter that you got. I mean, some of the calls been kind of getting out of hand. People attacking the principle of what you're trying to teach, and the people that have been involved in listening, they know what you're doing because we've studied to show ourselves approved and check everything that you've said far. And I commend you on this man in a gentle way to check his facts.
Yeah, because I don't see any facts that he's supporting his point of view at all, other than just saying that I'm all washed up. that there's nothing to counter my facts that I've given on all these programs, other than just an out and right thing that I just don't believe. There's no question. There's no counter facts he's coming back with. In other words, he's got a conclusory pleading, and he stated a claim that he can't be granted. Yeah, he's failed to state a claim upon which relief can be granted. He's done a 12b-6.
I agree.
Which is very immature, really, because that's our whole problem all along. You know, we're supposed to be quick to hear and slow to speak and check out the facts. And that's what I don't appreciate. When the facts, I'm giving the facts, and you're obviously you're either ignoring the facts or else you're not checking them out for whatever reason, because maybe you listened to 5 minutes and said, "Oh, this doesn't make sense." Okay, you know, this is not really for everybody, and I don't expect everybody to get it within 5 minutes. But you know, here, at least if this could be just another tool to put in the toolbox. But I think it's more than that. I think this uncovers the whole system, how it's been on.
Yep.
Much more than that. If we get this down, I think this is going to lead to 100% success rate in any kind of remedy that you're going to get.
Christian?
When I came to the spendthrift trust and the protective trust and the discretionary trust, because that right there, just points out why we haven't been able to get a remedy under any kind of consistency rate. Methodology you use from A to Z, everybody gets about the same success rate, which made me think, you know, how come one's not better than another? And how come when somebody can take and duplicate exactly what this fellow did over here, who he had a success with, and then do it exactly like he did it, and I don't have success? Something's kind of fishy. So it made me look and re-examine things again from a different perspective. And then I started seeing things a little more differently, and I thought, well, I better check this out a little more. So I check it out a little more, and I get my eyes even wider open and finding out, wow, it's even bigger than I thought. So I have enough beating people up, but anyway, for defense myself.
Christian?
Yeah, who's this?
It's Jacob.
Jacob, go ahead.
Can you speak a little bit about the cleaning up the IMF record?
Well, we're going to do a Treasury directive on the 25-06, which is just calling a directive hearing, and that could be nothing more than it's just going to sit on somebody's desk for a couple of days until they get the facts all together, and then they look at the facts and say, okay, bing, that's done. I mean, it's not a hearing that you're going to attend. The Treasury directive, IRS directive 25-06, which calls it board hearing. And then I'm going to throw in that USAM, that U.S. Attorney's Manual, under that 6-4.010, which basically says that master file, that IRS record, all other agencies must comport to that. And it comes back down to who is the one who puts the information in that individual master file in the IRS. We do. And we're the only ones who can correct it.
Okay.
And we're the only ones who put any information in there and set ourselves up by declaration on the 1040 form, which not many people know that declaration of a trust, and you appointed yourself as a status as trustee on that trust. Now that master file contains the trustee status as being you. All other agencies got to comport to that.
Okay. Are you going to go over that in your workshop, all that?
Yeah.
Did you get my thing for the workshop? I want to be in it for 2 months. Because I sent
I haven't read my emails in about a week, so I'm about a week behind.
I believe it.
So anybody that has made a request for an application registration, I probably got it, but I just haven't responded to you because I haven't jumped on the next thing, which was put the registration application together. So.
And when would the workshop start?
Well,
Okay. Is there any way to prep before then?
Get the Gilbert's Law Summary, official comments, and you got to have the official comments.
Official
and get
comments,
yourself
okay.
Black's Law, say like 8th edition, 9th edition.
6th won't cut it?
Pardon?
The 6th edition wouldn't suffice?
Well, yeah, I like to have one that's, we got some digital copies, which I'm going to be putting up on the website, like the first, the second, and some others. But I like to have some of the older versions because that's going to comport to this 1888 version that we're the treatise on law and trust that we're working on.
Mm-hmm.
And I like to have the modern version, like the 8th or the 9th, which is going to put it more into a definition in the present tense.
Mm-hmm.
So a 6th doesn't, hinder, but I think an older one and maybe a more modern one might.
I was just looking at it, and conveniently, the trust special deposit is left out, but it does show up in the 6th.
Yeah. It helps to have many copies of Black's Law or even a movie.
Well, I look forward to when you get those other ones up because those are very interesting too for comparative.
Yeah, I was going to put all that on the website. Documentation and backup research stuff and all that stuff. That whole website's designed to be for just trust. So.
What did you say that Treasury was 2506?
Yeah, 25-06. Treasury Directive 25-06.
Christian, on that IMF record, if you were a multiple citizen of many countries, of several countries, is it going to have an effect?
Well, if you have a status in the IRS or as a citizen, U.S. citizen, you probably got an IRS master file record.
Uh-huh. But, I mean, if you have other citizenships and you have other passports and you're in other countries also, and you're an international multiple citizen.
Okay, but what are you a citizen of? Multiple citizenship, is that what it is?
Yeah, several countries.
Yeah.
Does
they
it
all
matter?
operate under debtor-creditor, the same problem we got here in the States, so. But I don't know about, termination of other country status. That's a whole different issue I haven't really.
Yeah. Mm-hmm. I mean, wouldn't that have to be done maybe as the International Monetary Fund, the IMF, individual master file, that's under the IRS, but is it possible that that's also under the International Monetary Fund internationally?
Well, it could be, but the IMF that I'm making reference to is the IRS individual master file.
No, I realize. But there's also the IMF, the organization.
True, right. Mm-hmm.
And I've always wondered why they had them both called the IMF.
Yeah, could be a point there. I don't know.
Okay.
One door backward, same entity, maybe? I don't know.
No, I think it's some kind of sleight of hand deal. It appears that way, anyways. But in using the trust, the NTT, in areas of commerce such as mortgages, can you expound on that a little bit? How it would work as opposed to the DC?
The DTC.
Not DTC, debtor creditor.
Relationship. See, anything involving a negotiable debt instrument is going to be in the public realm, and it's going to be debtor creditor, which takes in all the facts that we did with all of the bonded promissory notes and all the set-off bonds and stuff that we did and all that stuff that we put in the Treasury. Here we were doing nothing more than creating bigger debts and making ourselves bigger debtors, and thought we were accessing the private side, which I don't believe we accessed anything on the private side with that. No, based on what I know now.
No, I think they're doing something else. Because they're giving part of themselves away. By doing all that.
Yes, I look at it as that if you got to go in asking or answering questions and they're doing all the asking
right.
questions. Then
absolutely.
you're not coming in as king asking questions yourself. They're asking the questions, and they're king.
Mm-hmm.
And I think that if you do get something from that, if they slap $35 billion in debt certificates on you, if you take the temptation and go back and use those debt certificates and use them as money back in that debt realm, you're just falling back into the trap, and you never accomplished anything in getting out of anything.
Okay. A question about the W-8. I have an account that I go through a W-8, and I don't even appear ID, and I operate as power of attorney on behalf of a W-8.
Uh-huh.
So I was wondering if somehow in the IMF, instead of playing their game, somehow you could have the sleight of hand like the double IMF.
Possibly. I haven't thought about that. I don't know.
Okay. If in a mortgage situation you have a first and a second, and the first is institutional and the second is private money, how does the trust relationship look?
Well, I disagree that it's institutional. I would say that was probably the debtor-creditor relationship, only because you didn't express it to be a trust from the start. And the only one that doesn't know.
Oh, I see. Okay. But what about if it's private money?
Or operating under a trust all along, which they're duping you into believing it's debtor-creditor because you didn't know or understand.
Yeah, but if you were going to deal with a mortgage situation and you had a first that was from a bank and a second that was from a person, you'd have two separate trusts, right?
Well, that may be a private trust between the person, which is strictly private there, and the bank is more of a statutory trust.
Mm-hmm.
So you got two trusts. Yeah, you're dealing in two different scenarios there. So a private entity, although that could be construed as the fiction, though, really. That person probably has a Social Security account. You could treat that as a fiction and as another separate trust and treat it all. You could get both trusts at the same time.
Or if they were a private company or something, they would have an EIN number as opposed to a Social Security or whatever.
Yeah, it definitely would be a statutory trust then, for sure, then. But yeah, it would encompass both, all those two trusts, and terminate both of them simultaneously. Another question?
Yeah, Christian Bill here, Michigan. We were talking last night, Chris and I, about the process to pay the war debt.
Mm-hmm.
Have you worked that out in your mind on how to tender that offer? Because
well, it's not an offer. I don't give any offers. I give orders for settlement.
Okay, so have you figured out in your mind how to issue that order for settlement?
Yeah, first I'm going to acknowledge the debt, and then I'm going to give an order for a settlement. Then I'm going to give an order for a merging of the titles. And it's nothing more than, say, Section 159 in Gilbert's, which talks about merging titles, and merging of the title, that is the payment. So I'm going to take the title to the debt, past debt, present debt, and future debt that I might have concurred under this account. And I'm going to merge an equal amount of assets with the title to the debt. And when I merge that in one entity, both those assets cancel each other out on a merger. That's payment.
Regardless if we're actually given a figure, because it's just a piece of paper that we're going to merge in.
Yeah, the example I gave earlier is somebody just gives me a piece of paper as an offer for a bill. It could be just, they just say any amount on there. It doesn't make any difference. That whatever it is, the in kind I give back. And under trust, it doesn't really have to have value, as a dollar amount, because we're talking about trust res. It's the thing, and the trust property does not have to have a value. Under debtor creditor, you have to have a value because they want to tax it. Under trust, you don't. We're talking about a thing. So I'm talking about a piece of paper, a thing. Whatever the offer was, or for the debt title, is going to be turned into a counterpart, which is going to be the counter or the antithesis of it, which is going to be the asset under a special deposit given back to them. So they both equal each other, and then when they merge together, which they're all merged because it's one piece of paper anyway, they cancel each other out.
Mm-hmm. And that transfer on the UCC3,
mm-hmm.
is that done as the assignment? Is that what
you're doing an assignment? Yeah, you're doing an assignment, which is a transfer.
Okay.
And that's one of the methods of formation of a trust.
Okay, so the assignment equals transfer.
Yeah, that's the present transfer of trust res property. That represents the notification of that. It's not exactly the 3 that is the mechanism that forms the trust. It's the present transfer. But the notice, the UCC3, is a notice, and it might be reflecting back to a present transfer that happened, say, 3 years prior. It's just a notice. But it's creating a record that I can use as proof that a trust was formed, say, 3 years prior. Because it's when the actual trust res property was put in the hands of the trustee, which could have happened 3 years before. And maybe I just get around now because somebody hit me with some kind of obligation trying to collect, then now I need to prove a trust. And so I create the records that indicates that 3 years prior there was a trust res transfer, and that's on the UCC3. So it's only a notice.
Now, let's just create a hypothetical. Let's say I'm not in this situation, but we'll create a hypothetical. You're made presentment for a court appearance, and you accept that thing, and then you reassign that back to a trustee. And that trustee could be the prosecutor, it could be the judge. On box 7, are you going to add that individual or that that entity's name on there?
Yeah, that trustee's going to be in block 1.
In block 1.
Yeah.
On UCC3?
On a 3, yeah.
Block
Trustee
1
goes in the debtor block.
Well, that's a UCC1.
Well, the 3 same as the debtor block transfers through on a 3.
Okay. But what we want to put that party's name in there is what you're saying, and it's going to be the all caps entity.
Yeah, whoever the debtor is going to be the on the form there is going to be the trustee.
Or you're going to be doing his assignment.
Yeah, on assignment, yeah.
Okay.
You're going to assign it to the trustee. And I would like to see it to be myself, to be the judge.
Now, why wouldn't, let me ask you this question. Why, if you're making a special deposit, because I'm fooling around with this right now, and I sent some stuff over to Chris, maybe he'll shoot it over to you and you can look at it. And I'm just, doing some testing right now. Why wouldn't you, if you wanted to make a special deposit, let's say you get the a registered mail number, and you put that on a piece of paper, and then you non-negotiable, and you deposit that into a corporation. And you say, here you go. Do what you want with it, but if it doesn't work for you, send it back to me. We've just formed a trust. Now, if I take that registration number and I put that on as a collateral change on a UCC3, okay, now, am I not also indicating the trust or indicating that that is now trust property because we've already got a UCC1 in place under Baylor Bailey arrangement?
Okay, who's the trustee?
The all caps, the trustee would be me and grantor. And I'm depositing it into a corporate entity and saying, here, put this on your books, use it for set-off if you'd like, ledger it according to GAAP. It's given to you in trust as a special deposit. If you can't use it, send it back.
Yeah, when was the trust formed?
A couple years ago. Actually, no, the trust was formed. The trust was formed as soon as I drafted the order to what to do with it.
When was there a present transfer of trust res property?
Today.
Okay, the trust didn't exist until today then.
Well, actually, the trust was created a couple years ago, but the trust.
The only way that it's created prior to that in the past is at a transfer of trust property to a person being the trustee. It has to be a present transfer of trust property, which could have happened 3 years prior, but somewhere along the line it has to be a present transfer. In other words, you can't have a trust. The key to the formation of the trust is when there is a present transfer of specific trust property to a trustee.
Did that 2 years ago.
Okay, so
all I did was add another piece of property to it with this registration number, and then I made a special deposit to a corporate entity today. My city, along with my check for the winter taxes. So I made two deposits.
A little more specific information.
We'll talk about it later.
Okay.
I don't want to. You're doing a great job here. We've got a group up here in Michigan that a focus group, and we had Chrisitian on it last week, and he may have told you on Sunday, and we think you're doing a great job.
Okay.
So anybody that doesn't understand what's going on here, they don't understand, and that's fine because there's enough of us out here that understand what's going on, and you're doing a phenomenal job. We've got a number of people across the country that recognize that, and we tip our hat to you. Thank you very much.
Christian, it's JC. I have a question.
Yeah, JC, go ahead.
I want to go back to actually what Rhonda and the gentleman after Rhonda were talking about, which I think is fantastic. The idea that you get a presentment in the mail and you put there's some confusion about whether you want to A for B that or not, and I don't think you do anything other than just sign it and express it as grantor. But your signature is the claim. Your signature is a claim on that. The UCC1 is the notice of claim. But by taking that presentment and putting your signature on there as grantor, now you're claiming that.
Right. Then when I do the UCC1, I've created a notice that I have claimed it. Not mine. Nobody said anything otherwise, and then I can move it on a 3. I can merge the title.
And you merge that by sending it back to...
We don't do any except for value, return for value stuff at all. That's debtor creditor, although I liken it to what we do under trust, which is really on page, I think it's 127. 127 under section, 462, I think. Let me look quick.
441.
441, yeah. Yeah, 442. starts at 441, but 442 specifically, that's where the transferee's right. That right there, 442, is really likened to except for value and return for value, although it's not except for value, return for value. This is trust. And it achieves the same thing as what an except for value, return for value does, but only under trust. Because you're flipping the liability and transferring it back to the other party that gave it to you. Same thing with except for value, return for value does. But we're not talking about value. Value is debtor creditor. We're talking about res property is really the thing, and it does not have to have a value. So like for like, in kind for in kind.
So when you're going to put your mark,
Go ahead.
when you're going to put your mark on top of that presentment, when you go back into the olden days of also putting stamps and canceling that out, or putting your seal onto that both exchange,
Seal.
do you think there is value in doing things like that?
Value as to monetary value, or that we should do it because it, well, I think if the signature is seal. I mean, really all I have to do is put my thumbprint on it. I don't even have to sign it. That is my seal. That's my unique mark, my thumbprint. That's all I'd have to put on there. But I like putting a signature on there. That's my mark. I really don't have to put a thumbprint because my signature is good enough.
Christian?
In fact, I could probably prove it without a signature because comes back down to my intent and purpose, which comes back even farther yet, comes back down to I know and understand, which means I'm sent here. And that demonstrates purpose because I know and I understand. And nobody can take that intent and purpose and express it other than me or change it other than me. And as long as I don't get anybody to coerce me into changing it, it'll never change.
Christian?
Yeah.
The remark that you made about the signature and the thumbprint, there's an area where we are not supposed to swear.
Mm-hmm.
And the signature is like swearing. So the thumbprint or nothing, the intent and purpose would be the ultimate goal for the least amount of liability.
Well, how do I prove my bond and my word? That's what it really boils down to, Whatever my pledge or security for that pledge. My promise is my word is my bond. And that really demonstrates my intent and purpose, really.
As an example, when you go to do the work on the IMF, do you do a request first?
Well, an information is you check in Black's Law, it comes up that you're making a charge. So I'm not going to really make a charge. I'm going to make a declaration or a command or an order.
No, I mean a freedom for information request, so that you know what.
No, not really. No, why would I do that? I mean, to discover how much is in there or something, how much I owe, or
no, to discover if there's something in there that you don't know what they have on you.
That doesn't make any difference to me. Just take that and cancel it out with my title to the asset. Whatever the debt is, I don't really care. Let's just get this all account zeroed out, and let's just start anew. And that way, whatever they've done in the past to mess all this up, how they've shifted the books around to cover that I was functioning as an arms dealer in Afghanistan for a $5 million black. Just cancel all this out and start with a clean slate.
So we don't really need to find out what's in there. We just need to cancel it and clear it out.
Yes, I'm just issuing an order. Whatever debt titles exist under this account number, here's a corresponding order for a merger of a title with cancel it all out. Do the discharge on the, here's the order for the discharge on the public side and an order for a set-off on the private side. And now, for the settlement. Close and settle this account.
Expressing trust.
Yes. So I'm giving orders or
And that's what the diff?
Or, you know, I'm giving orders or directives or commands on everything. I'm giving an order for a settlement. I'm giving an order to merge the titles. I'm giving an order to do the set-off. I'm giving an order to do the discharge. I'm not using any precatory language like I hope, I will, you know, or I request. You know, this is all precatory language. But I can't do any of that without first having established that I've made a claim, there is a trust, and I proved the trust, and now I have the authority to give a command.
And how am I going to do that?
Well, I'm going to say that there's a trust that exists, it's my trust, and I'm going to come in with the proof that I'm the grantor on that with the proof of the two records. Claiming the title. And once I've established that I'm grantor, now I can issue the orders. I've got the authority to issue the orders.
Can you walk with me on that one as a layman here?
Well, we've got plenty of downloads from the past. If you'd listen to
which one?
Shows, you know, starting with like 11.7 from the NTT announcement. We've gone over this maybe 100 times already.
Do you know which one that has that specific on it by chance?
The one that maybe to start out with would be 126 of January 2010.
Oh. Okay.
The first hour in detail about, you know, how to terminate the whole thing from start to finish.
But not in relationship to the IMF, though, on that one.
IMF, you mean as in relation to the individual
master file? Huh?
The individual master file?
Yeah.
Yeah, 126. That's when you'll look
really?
at.
Okay.
Yeah.
There's no shortcuts here. You have to listen to all of them.
Thank you. Appreciate that.
Yeah, we all been there.
Well, I'm not trying to be mean.
I've already listened to 126, and I must have missed it.
You've got to listen to all of them. I mean, we've all gone through it, and the thing is, you have to study to show yourself approved. And this is what we're all learning right now. And you know, we've all been there, and we're all reading, and we're learning, and you know, double checking, and making sure what he's saying is verifying it. And this is what you have to do to prove it in your heart that it's right.
Well, I have the witness. I know he's on it. And I checked out the whole debtor-creditor thing, and my spirit was like far away from the darkness. And I can see that this area has a lot of clarity.
Okay, another question? You got something else? Anybody else have press star 6, state your name, where you're from?
Hey, Christian?
Yeah, Rhonda, go ahead.
Back to the title that they're sending you, the debt title that we're going to turn into an asset title that we're going to put our signature on. Would there be any problem putting like the an RA number on that actual title?
In fact, that's probably what I would put on it, yeah.
And then we could correlate that back to the orders that we're going to give to in our expression and what to do with it. So that way, we got an identifiable document.
Right. Specifically identifiable.
Right.
It's got some unique numbers on it that can't be anything else other than that.
And
Especially if it didn't have any numbers on it to begin with. Although I imagine they're going to have some kind of account number or something, which would be a specific identifiable number.
Yeah, but that's their debtor-creditor account. We want to turn it into our trust account.
Yeah, you could put your number on it, just to play safe if you wanted to.
And now, since we're turning that into a non-negotiable, that's basically a non-negotiable instrument now that we're going to make a special deposit back to them with. So is there any problem, because now that it's a non-negotiable instrument for payment, they get the original. Is there any problem with making a copy of the non-negotiable instrument, payment instrument?
For you or for them, you mean?
Well, they're going to get the original because that's a payment instrument, right?
Right. Mm-hmm.
Following the rule of forms, we want to keep the original on everything, but a payment instrument.
Yeah, but then I'm also going to be issuing a certificate of deposit because I'm the depositor.
Right, so I'm going to send them back the original as a payment instrument, as a non-negotiable special deposit payment instrument. So is there any problem with me making a copy of that non-negotiable payment instrument for my records and stamping a copy?
Yeah. Mm-hmm.
Okay.
Okay, any other questions?
Christian,
Yeah.
David, would that be considered forfeiting, though, unless you stamped a copy?
Forfeiting?
I mean, not forfeiting. When you print money, what is it called?
Forgery.
Forgery, rather. I mean, would that be considered forgery unless you have it stamped with a copy on it also, the one that she wanted to make?
Well, it's a special deposit. What I give you, you got to give back to me. It's non-negotiable. If you negotiated, you did a conversion. You broke the law, not me.
Okay. All right. So, for people that would do that and send it back, and then they would say you had a situation where someone, where an institution kept sending them to you. They're wanting to get paid a lot of times, or is it because you're, yet set off with the IMF file?
Well, they probably could maybe send it to me maybe before I got it, the record, but then I'm not going to pay it twice. I paid it once. Why would I pay it twice?
Would you send them a notice of that here's a copy, you've been paid?
No, I would bring them back to the deposit that I made the first time, which made the payment.
Okay.
Here's a definition of special deposit under Bank Officers Handbook of Commercial Banking Law, under the 6th edition, under Section 19.02, Section 2C, where it says, quote, special deposits may take a number of forms. Sometimes they are a means of holding funds in litigation, trust funds, and the cash securities of various types, such as deposits to show good faith in the case of contracts and the like. Accounts to hold funds of clients to whom they are fiduciaries. Special deposits are created by special contract between the bank and the depositor. In most instances of special deposits for the benefit of a third person, the bank becomes trustee of the deposit for the benefit to the named person. Special deposits are often payable upon demand, sometimes upon terms, and occasionally they bear small amounts of interest. In many instances, such accounts are evidenced by certificates of deposit. And then you could apply that trust deposit definition under Black's Law 4th edition revised, where it says that, or payment of particular debts or obligations of the depositor, or devoted to a particular purpose of the depositor. Another question?
Well, Well, then, so do you always need to include some instructions with them? Like you said initially when you first, got on the subject, just your signature is enough, and you don't need to do anything. Or like we say, some trusts don't even need words or anything, or to be informed of that. Do you need to? Are you required to add instructions like?
Well,
if I give you my pen and say that you can use my pen, but I want my pen back, say in 2 weeks, or when you're done with the use of it, then, was there any kind of special instruction?
Le dio $4.
Well,
Yeah, you got some background noise, plus *6 if you're not speaking.
Oh. I thought it was on the Spanish station for a second. Yeah, where do I switch my language or subtitles? No, but like where you were going and pointing out, you would acknowledge it, then you would give it an order, an order to discharge it public and settle the private and all. And then you would also instruct or order it to be merged. Are those not instructions that you're
specifically spelling out what I want done for my purpose, my intent? Yeah. I mean, I could make it as specific as I wanted, but, I kind of like sometimes maybe making things very broad so I could interpret them any way that I really wanted. Otherwise, if I specifically word something, now I'm down to a narrow path that everything has to be carried out. And I've got no room for, leeway playing around if I wanted to.
Exactly. The signature is enough, probably, then.
Yeah, really. I mean, as long as I'm still alive, I can express my intent if somebody misconstrued, and I can go back in and correct what their mistakes are.
Yeah, or your own. Right. So then it would be sometimes suffice to send them the receipt, the UC3, the addendum to the one, instead of.
Yeah, I'll probably give them a certificate of deposit.
Okay. Certificate of deposit. Define. Let me look it down up.
Say that again.
A certificate of deposit would be the same thing, a copy?
Yeah, I would give them a copy of the certificate of deposit, yes.
Okay, all right. Okay, that sounds good.
I could come to the bank officer's handbook on certificates of deposit, which is the next one down from special deposit under that 19.02 section. (1902) the certificate of deposits, or CDs, are instruments issued by the bank specifying that a certain sum of money has been deposited. These certificates may either be negotiable or non-negotiable. Now, the negotiable is public and non-negotiable is private. So we're going to be issuing non-negotiable CDs. When non-negotiable, the bank simply contracts to return the amount to the depositor plus any contracted for interest. And you could specify interest in there. So if the certificate is negotiable, the bank agrees to pay the depositor or any person whom the depositor shall order, or the bearer of the certificate. And when the CD is a negotiable CD, the debt of the bank is to the legal holder of the certificate and not to the original depositor. So there's your CD, which is the title to the special deposit.
So then, do you think that would require also special mailing? So receipt of
registered, yeah.
Yeah, registered. And then, if you did add instructions other than your signature, that letter should on the RE or the header or something have the number on it too, right? The register.
Yeah, I would put the numbers on all my documentation to signify it's all one package and it's all of one thing.
And stapling, does that matter? I mean, I always feel I should because I feel somebody's not going to pick it up and use it for a coffee, you know, to put their cup on, and then it loses its place with the other document if you have something like that. Is that wrong to staple them?
Well, no, I like maybe numbering them, because if you put like 1 of 6, 2 of 6, 3 of 6, 4 of 6, 5 of 6, 6 of 6. Now you got something specifically named down.
That is a good one. Perfect. Okay. That's got me for now. Thanks, Christian.
Okay. Anybody else? Question? Comment?
Yeah, I have a question.
Go ahead.
Under the debtor-creditor view versus the trust law view, how do we view the signature as having weight, being different between the two?
Under UCC, having weight. Well, I think both of them granting your authority to do whatever you set out your intent and purpose. One's going to fall under colorable contracts under UCC, under debtor-creditor, and the other one's going to be under trust. Private, public.
Right.
You're always looking for a signature on there. You know, they need this signature to get your empowerment or your authority to do whatever they want to do under the debtor-creditors. And under, say, trust, you want to put your seal.
So, under debtor-creditor, the signature would be required, as opposed to under trust, your seal could be your word, your seal could be your thumbprint, your seal could be your signature.
Right, could be, yeah.
Right.
And so how can your spoken word be expressed in the way a physical signature, in other words, a verbal command versus an action?
Yeah, okay. Here's a simplified way of maybe looking at it. Everything that happens in the debtor-creditor realm is looking for a written record. Because they can't see anything that's, say, spoken by the real man or woman.
Okay.
They're looking for a written record. And that is what they look at as being the manifestation of your intent and purpose, even though you didn't know or understand what was going on. In other words, you didn't have to have sentior knowledge in the public. So we're going to come in on a private side under trust, and we're coming in chambers, and we're going to be there where our word is our bond, and we don't have to have a seal like a signature like they do out in the public, because really it's what the real man says. But remember, what he says could be in writing, on paper, in chambers. Because it could be your oral words written down. And now you have to have knowledge or understanding or sentior in that private realm, where on the public realm you didn't have to have sentior. And what really makes you a fiction is that you don't have the knowledge or understanding in that public realm. And when you do get it, now you're not a fiction. If you don't know or understand what's going on, you are a fiction. That's the key, the crux of it all right there.
Say it again, please.
The definition of sentior.
Censure?
Yes, S-C-I-E-N-T-E-R.
Oh, center.
Yes, sentior, yep.
And what is that?
Well, on the private, sentior, to be sentior, you must know and understand. In the fiction realm, in the public, you do not have to know or understand. They get you to confirm your intent or your knowledge or understanding by a record that they duped you into acting, and they can certify your action, and your action, you don't have to have knowledge or understanding of what you did.
So in chambers, you could actually be in the public or the private.
Well, in chambers, I'm in the private.
Right.
No, but a debtor creditor will be in the public. In chambers.
Right, and that's the difference.
Because I happened to be in chambers the other day with a debtor creditor, and I was allowed special visitation during the meeting, and I watched him do what you're saying. I watched a debtor. He thought he was in the private, but I watched him get aced, and they treated him just like he was debtor to creditor, even though they left all his rights intact in the whole shot.
This was in the public, you say, or in the...
This was in the chambers.
In chambers, okay. So this was a debtor creditor that came in?
Yeah, you know, they took us to like 3 special rooms. Finally, you get in this special room, and it's one-on-one. And, you know, the statements are made about that this is chambers. I mean, with respect to, you know, all your rights are going to be reserved. You're not going to be entering the bar. Let me talk to you about this issue. It was about a mortgage, and it was about a big land grant patent deal going down in Southern California. I happened to be at the meeting, and there was an attorney in there, and they talked for like an hour. And the judge looked over at the attorney and said, "Did you understand anything we said?" And we said, "No."
Okay.
I almost wanted to start laughing. Exactly. But I realized, and the attorney, when he was asked the question, you know, he explained why he didn't know. And he explained, you know, the language that you guys are speaking, you know, I have not been trained in, and I don't deal in that, you know, framework of language. Therefore, I don't know what you guys are talking about. I don't want to know what you're talking about. I'm here to do, you know, this work that I always do, which is out here in, you know, statutory land.
Who did the judge favor?
You know what? The judge favored the guy, but he asked him, "Can you give me?" Because he asked him, you know, because of the jurisdiction, he said, "Can you give me one case that can support your, you know, your stance on this issue?" And then my buddy, he wasn't prepared enough, and he didn't have a case to throw out, so he ended up with disfavor.
Should have given him a maximum law.
It was his first time he'd ever done it, so he was a little bit shocked that he even got to that point.
Yeah, because I wouldn't want to use case statutory sites and stuff in chambers. I would want to use maxims of law. Because
Yep.
I'll tell him that.
Doesn't have to be true.
Bring anything statutory into that in-chambers thing.
Right, you just have to bring the purpose and the intent of the statute in there, right?
I'm not there to demonstrate form, procedure, and process because that's public side. I'm there for substantive rights.
Mm-hmm.
And substantive rights are maxims in law. And that's where my affidavits count.
Mm-hmm. Now, if you reverse engineer this particular trust law stance, and you take it all the way back into the origin of time from whence it first became what it is, I mean, you could go back, as they say that when Moses was on Mount Sinai and he got the so-called written word, and then he...
Farther than that, when Adam was granted the earth.
Yeah, of course. But that wouldn't be what you guys are talking. That's not trust law. That has to do with favor and disfavor, I believe, not law. You have to come up to Moses to get into law.
Yeah, well, we're not talking about law. Law is not equity.
Okay.
The equity is trust, and trust is talking about a thing, a res, a grant. And God granted the earth to man.
Right.
Adam.
That
was trust.
Yeah, I agree.
That was trust.
That's the best way that's one of the best ways I've ever heard it put.
Yep. There you go.
But when, I mean,
it's like a definition between the equitable assets, because they're saying that it does not fall under the description of legal assets. It says that for a debt or a payment of debts or legacies in equity, by an ordinary rules of law are exempt from debts, and where the grantor has voluntarily charged the asset and being non-existent at law, have been created in equity. And they can be reached only by the aid and instrumentality of a, and because their distribution is governed by a different rule from that which governs the distribution of legal assets. Two different realms. One's at law, the other one is equity.
Okay, I'll study up on that area.
The law that went back to Adam and Eve was a natural law, was the Creator's law, Yahweh's law. That was the ultimate law that was given to him in the Garden of Eden. And it's the original covenant or trust, which is based on law.
Well, I don't really agree with that, but it's okay.
Yeah, but then we couldn't even live by the law. We couldn't even live by the Ten Commandments. That's why what did it say the other day? The man hanging from the tree lived under the law. That's why we can't live under the law. That's why we had to get another grant, another trust property, like Christian said, the Savior.
But it's like this. It's really like this, though. It's really like choose this day whether you will live or die. And it's like you go to lunch and you have a choice to either eat right, where you will have life brought to you and the longevity of life, or you will bring death upon you. If you choose to eat dead food, dead water, you will get cancer and you will die. If you choose to to drink live water and eat live food, you'll live a pretty dang healthy life.
That's natural law.
You will. No, it's not. It's not law.
It's original law that was set down. You need to read Scripture, my friend.
Please.
Well, I believe eating.
You need to look. You need to look at what Scripture means.
I believe eating good food's good for you. However, man does not live by bread alone.
Well, my point was, I don't want to get into it. I'm not really interested in arguing person. Point was that you either, from your choice, you either have favor or you find disfavor.
Peace be with you.
Yes.
Yeah.
Christian, Christian, the Bank Officer's Handbook. What's the name of that, and where can I get it?
Okay, the name of that is Bank Officer's Handbook of Commercial Banking Law, and it's by Milton R. Schroeder, Schroeder. And there's, I have a 65 version and a 1989 version, 6th edition. And you could get that at any law library.
Yeah, I went on the web and I looked and I saw one by Botel or B.E.
Yeah, Botel, and I think there's two authors on there. It's
sure. And then there was an older one I found on Google
Frederick
Books.
K. Butel and Milton R. Schroeder.
Oh, the Butel thing.
Yeah, Beutel. Frederick K. Butel.
Okay, and then there was an older one from the 1800s by this other guy.
Could be. This is the 6th, and I got another one. I forget what version that one is. But it's 65, 1882. Something like that.
This one from the late 1800s you can download for free, but it wasn't a Butel and anything like that.
Right.
And I didn't know if I could, if that one would do, because there were 3 or 4 different ones,
Yeah.
So this runs about $90 to $100 each.
is that new or used?
There was only one place. I went up on Google Books, and Google, they had a second edition, the 6th edition. I went to look at the 6th edition, and it says buy, and only one place had it for sale, and everything was $94.
Mm-hmm.
So the books for this course that that you're having, I need to get to purchase them.
Yeah, that'd be Gilbert's Law Summary on Trust and the UCC with official comments.
Okay, I got a New York UCC with comments. But it's
New York UCC. Well, I don't know. Is it verbatim? I imagine it would be. But see, the numbers probably might not be the same, say, in New York as regular straight UCC.
Well, not so sure, because, for instance, give me one that you, out of one, I'll look it up, because I got it in front of me right here.
Well, like 9-210 statement.
Okay, 9... 9-210 in New York's UCC is request for accounting, request regarding list of collateral and statement of account.
Okay, same thing then. Yeah.
And then it's got official comment, but source former section was 9208, scope, purpose. And then right after official comment, it has, this one just has official comment. Some of them have quite lengthy comments. And then it has, some of them have a second comment section.
Yeah, under your 9-210, well, how's your official comment start out? Number 1 is what?
In section 9 is just all official comments. But the one I have is 2004.
Yeah, but under official comments, under 9-210, what's it say on number 1?
Source, former section 9-208.
Okay, and number 2 is scope and purpose?
Scope and purpose, it says this section provides a procedure whereby a debtor may obtain from a secured party information about secured obligations.
Yeah, and then 3 is by debtors only?
3 is debtors only.
Yeah, okay. So, well, it looks like it's reading the same then, verbatim then.
Yeah, and 4 is permitted types of requests for information.
Yeah, the important thing is the official comments, because that gives you some real meat there.
Okay. That's the one that, okay, so I already have that one.
Well, like on Cornell Law, and just look at the code itself, you don't get the official comments, and that's what you really need, the official comments.
Now, this is the Gold Book by Nexus Lexus. So now we get the Gilbert's on Trust. The next one is the Bank Officer's Handbook. We have to get that too?
No, you don't have to get that one. Let's see. The UCC, Gilbert's, and the Law Dictionary. Black's Law,
yeah,
8, 9.
I got Black's 7, and electronically I got 1 through 6. But I got a 4th edition hard copy and a 7th edition hard copy.
Yeah, well, I used 8 a lot, and since then they've come out with a 9.
Yeah, no, I don't have those.
I think the more law dictionaries you got, the better equipped you are. They're hiding the definitions, and that's your foreign language, and that's your translator.
Because I think the latest one I got is a 7.
Yeah.
Christian?
Yeah, go ahead.
Yeah, hi, this is Chris out in California. Just want to remind everybody that if you go over to lawlearners.net and go under Trust, we've got the new Trustees Handbook. Also, what's posted over there under Trust would be the Prison Treatise with Gene Keatings. And if you go under Definitions and Manuals, we have nearly every law dictionary, including Valentine's, a dictionary that was blessed by the legislation that far back in the 1800s. So we've got probably a half a dozen different forms of law dictionaries posted under, Definitions and Manuals.
Okay, good, great.
Yeah, so I just wanted to mention that.
Thanks, Chris.
Mm-hmm.
Okay.
Chris, can you repeat that, where that is at?
LowellLearners.net.
Thanks.
Yeah, and you'll probably have to, if you don't have a password, you'll have to obtain a password. And then once you go in there, go under either definitions and manuals, and the trust information's down in the trust section down below.
That's on the right side.
Yeah. Mm-hmm.
That's good.
And that prison treatise does have some pretty powerful information in it. I actually benefited quite a bit from that by Gene Keating's. I don't know if it is a debtor or creditor, but it's got a lot of good information in it.
Yeah. Okay. So, Gilbert, Black's Law Dictionary, those are the only two that's required.
Well, three things. Gilbert's Law on Trusts, Black's Law Dictionary, and the UCC with official comments.
Okay.
Christian?
Yep.
Yeah, Pete.
Hello? Yeah. Hi. We've also got a full shared site which has got the Black's Law Dictionaries 1 through 8. So that's sort of to do with the Skype group. I couldn't give you the URL now, but some of them, you know, if you add me on Skype, then I can get the address to you.
Also, too, if you look in that trust under Darren Michaels, his research, he has 11 files that he has passed on to law learners on trusts. That may be some valuable information in there, too.
Does he have his own name, Jared Michael, on the right side?
Yeah, if you go under trust, you'll see Darren Michaels. He has 11 different files on trusts.
Right, okay, I understand.
Pete, do you want to give your Skype name out? So we could...
Yeah. It's Cheeky Monkey 1, so CHIM for mother, ONKI, and then number 1. And can I just bring you to a point about the equity asset, Christian?
Yeah, go ahead.
Yeah. In Fourth Revised, if you look under legal assets, it says such property of a testator in the hands of his executor as is liable to debts in temporal courts and to legacies in the spiritual by course of law. Equitable assets are such as are liable only by help of a court of equity. And then it says 2 will.x.1408-1431. The distinction is not important in the United States. And then it says, in re Sperry's estate, 1 ASHM, must be Pennsylvania, 347, that portion of the assets of a deceased party which by law is directly liable in the hands of his executor or administrator to the payment of debts and legacies, 1 story Ek Jaw 551, such assets can be reached in the hands of an executor or administrator by a suit at law against him. And I just wondered what your thoughts were on that.
Yeah, it sounds like they're, going under more debtor creditor there now for the ability to get access to the funds so they could transfer the funds. Yeah. Where 1776 Declaration of Independence says, unalienable rights, you can't transfer them. So that kind of gives you the spread on how they're misconstruing it or construing it so that they can gain access to all the assets.
And it said except Pennsylvania.
Except Pennsylvania? Was it accepting Pennsylvania?
It was... No, it looks like it's citing a case Sperry's estate, and then it's got number 1 Asham, and it's in brackets PA 347. So I think it's referencing a case in particular. Sperry is spelled SPERRY.
Who points out the difference between equity and ad law? Even going by that definition there.
Yeah, it was just funny how it said that.
Did he say?
Sorry?
That was out of the 4th revised, Black?
4th revised under legal assets, yeah.
I read that once before, too. So.
It says when the distinction is not important in the United States. I wondered how that fell within the definition.
Well, I think maybe they're construing it's not important because they don't want you to know that equity is still available. Because what was it, in 33, they changed all forms of law and combining them into one summary judgment and really redefined equity to be really statutes and codes. And then they hid the real equity in chambers. And everything went into trust. Equity went into trust in chambers, along with the republic and common law and everything else. And now we have this colorable semblance of the colorable contracts, the debtor-creditor stuff, and the redefinition of the statutes and codes to be, equity on the public side.
Yep. Okay, thanks.
Anybody else? Question? No.
Last night you asked us to do a homework in regards to making something a simple statement, and I came up with something, but it was in regards, I researched it out of black laws. In other words, you say something in this regard: I authorize the reinstatement of the intentional tort, and that all refers to trust, the original trust.
You say that again now?
I authorize reinstatement of the intentional tort. Reinstatement and an intentional tort is referring to trusts. It's using their code words.
Okay. Anybody else? So how would you use that in application for, say, the electric bill?
I didn't know I was going to be quizzed.
you stepped into it.
Awful choice.
That was the invisible snare.
I don't know. I would probably put that on the. If they send me a bill, just write it on there and return it back to them with my signature on there as a grantor beneficiary.
How about this? I direct you to separate my records for future return. Now, does that sound like a trust or anything? And what would my record be pertaining to?
The special deposit.
Res, which would be the offer that they're giving me. So I'm directing you to separate. And what does commingle or in-kind or segregation
Right, for the trust.
So if I'm telling them to separate my records for future return,
Perfect.
look up the definition of return in blacks, look up the definition of separate, and I want to look up the word records too. So I could just say, here, I direct you to separate my records for future return. So that we'd have to have segregation there because we're going to keep it separate and you're going to return it back to me. Then, so I specified my intent that I want that back because you're going to return it to me in the future. So I left it open. You could return it back to me whenever I direct you to, but I've directed you to separate it. Now we got a trust. Because the key to a trust is keeping the trust res segregated. Just like on the $20 bill example I gave for the $500. They didn't ask for segregated funds. They didn't ask for the specific $20 back. They just asked for any $500 to be returned. Well, then that lacked one of the elements of form. Was specific trust res kept segregated. Now you're lacking one of the elements of the formation of the trust, and you do not have a trust. You have a debtor-creditor relationship. So it kind of fits that I want my pen back.
Right.
Because I couldn't get my pen back exactly unless you kept it segregated. So there was kind of like you'd have to give me my pen back, you'd have to segregate it.
And because they got your Social Security number and everything else on record, you don't really have to do like a debtor-creditor thing and stamp it and all that. You just put your signature as grantor beneficiary.
Yeah, and that would be my records of the offer that you gave me, and I give it back to them, and I direct you to separate for future return. So I've got to recall my special deposit sometime in the future. I could give an order for conversion, and then I could merge the titles, which would terminate the trust deposit.
Now the question is, that you'd send that to the person who sent you the presentment, but what goes to the United States Treasurer, who is the one who's supposed to make the transfer?
I'd send them all copies and call a dib hearing and ask them to correct all the master paperwork.
So the Treasurer gets copies?
Yeah, uh-huh.
Okay. Because from our previous conversation, I was understanding that there were at least two entities involved. It's like in the debtor-creditor relationship, I may be the drawer, okay, and then something, perhaps the DTC would probably end up being the drawee, and the payee would end up being whoever gave me the presentment, that three-party instrument. So the trust version of that three-party instrument would be the certificate of deposit from me to the presenter with the the drawee as the treasurer.
It could be the one who gave me the offer, because it would be the same. Unless the treasurer gave me the offer, I was just going to send the record keeper to the bookkeepers.
Okay, because what I was thinking of, because the three-party analogy would be the treasurer would be the drawee, I'm the drawer, and then the payee, the person who gets the payment, would be the one who gave me the presentment.
Right. The one who gave you the presentment would be the payee, yeah.
Okay, so a certificate of deposit, if it's drawn correctly, then would basically allude to as a three-party instrument. It will be presented to the payee, but it would list that they would have to send that or negotiate, not negotiate, but send that to the Secretary of the Treasury. I mean, not Secretary of the Treasury, but the Treasurer of the United States. Then.
Yeah, but in case they don't, I'm going to anyway.
Miss Rios.
Like, they're supposed to send it on, and because of the accounting, the IRS is supposed to do the accounting. But if they don't, I'm going to send copies and make sure that it's done.
But no, the IRS is the Treasury, Department of the Treasurer, which is on the other side of the coin. So which one would I send it to then? If I send it to the Treasury, the Department of the Treasury, to the IRS and the Secretary of the Treasury, or to the other side where the United States Treasurer is, which side do I send it?
Well, I think if you send it to Rios, it's going to end up with the IRS anyway.
Christian?
Yeah. Mm-hmm.
There's an interesting comment in Anti-Shysters on trust that matches exactly what you're talking about. Let me just read it off. It says, whenever a single individual holds both the legal title and the equitable title to a trust property, the subtitles are once again unified into a single perfect title. The trust is said to be executed and cease to exist.
Right, and that's payment.
Shyster.
The order to merge title, it says payment.
That was by Alfred As. Yeah, that was one of his articles.
Christian, it's JC. I have a question.
Yeah, JC.
I'm sorry, but our group faded out, and I had to redial in, so I was disconnected for about 45 seconds. But without too much background, you were talking about the record pertains to the trust res. That's the offer that they gave you, and then when I picked up, we were talking about the three parties. Can you explain what happened between those two conversations?
Yeah, he was saying, where do we send the parties to Rios or the IRS? And I was saying that, well, if you send it to Rios, it was probably going to go with the IRS anyway, because I think they right hand, left hand, the accountants have to keep track of the beans. They're the bean counters, so even if it goes to Rios, it has to be ledgered in the accounts by the bean counters, IRS. And then Chris came in with an Adask article there where he was talking about merging of the titles.
Oh, yeah.
I was saying that the merger of the titles was the payment.
But now, if you put the statement, I direct you to separate my records, then you're not merging.
Well, under a special deposit, not at that particular time, because I hadn't ordered them to merge the titles yet.
Hey, Christian, what was that statement you made earlier? You said, I direct to separate and then to return? How did you...
I direct you to separate my records for future return.
Hey, it's JC again. That's exactly where we got dropped off. That's the last thing I heard is, I direct you to separate my records for future return.
And I liken that to the same thing as when I say, I give you my pen and I want my pen back.
Estoppel.
It's like kind of like we had to have a segregated trust res in order to ask for my pen back, and I was trying to think of a way to take an offer like an electric bill, my records, and how do I return it back to them, saying that So I came up with the what I did was I just took in-kind and commingling and took some definitions as to trust terms and then looked them all up in Black's Law and came up with maybe a different verbiage, and I ended up with, I direct you to separate my records for future return.
Could you use that same statement in the court? In camera?
Sure, any kind of offer. Now, I also had, on the end of that, I also had, I direct you to separate my records for future return in kind after use. So there was a little, caveat on the end there. So I could have specified my signature as a special deposit, this trust assets, to be use. After that use, then to return it in kind. And that use could be payment.
So basically what that actually is saying is that when you direct them to separate my records...
Non-negotiable private equitable asset.
Yeah, so what you're actually setting up a trust.
Yeah. Mm-hmm.
Yeah, okay.
So the last example, I'm putting the in-kind after use, which is stating for a specific purpose. After you use my signature for whatever the documentation was supposed to be, the electric bill record, use my signature to do the payment.
Thing is sending it up to Rios too in regards to the Declaration of Independence, something that simple.
Yeah, because really I'm going to merge the title then at that point, and once I create the records, then I could send all the after the fact to the record keeper and have them make sure that the account is zeroed out. Because at that point, it's already been zeroed out. It's a past tense transfer.
All right. So let me make sure I got you straight here. I direct you to separate the return and use in kind.
That was in kind after use.
Oh, but it was for future return in kind after use?
Uh-huh. But I think in its simplest form, I direct you to separate my records for future return. That leaves it wide open. Because as soon as I stick in kind after use on there, now I'm limiting it to only to what the use was supposed to be for. So now I'm on a little narrower path.
Right.
Christian?
Yeah.
How would you apply this in ordinary life, like just in work or something? Like, say you make a deal with a party, and they promise to pay you $100,000, and then they don't want to pay. So how do you apply? How do you compel somebody in that scenario in the community to keep their word?
Get them in a breach of trust, and have equity. Get them under presumption of guilt because they didn't make a disbursement.
But that's more of a contract than a trust, though.
No, that's not a contract. It's got all the elements necessary to prove the trust and one of the methods of formation.
Right.
All you have to do is put it on UCC 1 and then transfer into 3, and then go down to the county, and then you've got all the evidence to bring it into court and breach of trust.
Yeah. If I had a present transfer of trust res property, verified by the record on the UCC 3.
And in that case, it would be somebody's word. But if it was their signature on a contract, it would be a little bit different.
Well, you see, the record would be the manifestation of the intent, which proves of a past tense transfer, a past tense present transfer.
Wouldn't that be considered trust res? You can use it as a trust res.
Yep.
Yeah, it would. I'm creating the record of a past tense transfer.
Christian, do you do any private counseling at all?
Yeah, that's going to be the next program I come out with. Yeah.
Because I've got a big project that you would be great at.
Well, I like to teach people how to fish. That way I don't have to feed everybody. Because if I have to feed everybody, I can only feed them one meal a day or one meal every 3 times. But if I teach you how to fish, now you can feed yourself for a lifetime.
Mm-hmm.
Bring your own worms.
But still, our buddy had, a dozen friends that he mentored. You know what I mean?
Yeah, but I have a few friends I would mentor, and then I can't mentor the thousands. So what's more important, to mentor the masses or mentor the few? I only got 24 hours in a day.
Yeah. Okay. So is that an affirmative or a negative?
Well, 24.
Huh?
I'm not saying yes, not saying no, but Send me an email.
Sounds like you might have a little Hebrew in you, my friend.
Yeah, I always walk down the middle, very narrow path. Yeah.
Okay.
Keep your options open.
What's the best email to use when you're not checking any of your emails?
Well, the hush mail, I'm trying to phase that out since I got the other one. .com. So
is that the best one? The movie.
Or Christian.
Because I emailed them all, and none of them get. I don't get a response to any of them.
Yeah. You know how many emails I get?
Well, that's what I'm saying. Is there another way to? Can I call you?
Yeah, but you'd have to get a hold of me by email and get the number or so.
Yeah, I can do that.
I have a question. The other week, there was a young lady on the line who only had Skype. It was blonde something.
Right. That was.
You're gonna get hurt to the cat.
It was who? Hello?
Yeah, she gave out her Skype name on the program there.
And I misplaced it, and I'm trying to get that Skype name because I need to get a hold of her.
I don't know her Skype name personally myself. You'd have to get a hold of one of the old downloads, wherever it was.
It was blonde.
Hey, Christian, it's Chris.
Yeah.
It's Donna Lee Ray, and it's Blonded by the Light.
Okay. Yeah, because
get that?
Yeah, she was going to send me something, but she apparently didn't have email or something. So I didn't have Skype. I need to get a hold of her. All right. Thanks. That's fine to me.
Hey, Christian, I've got a question.
Okay. Yeah, go ahead, Tris. Go ahead.
Since we're all kind of like just new to this stuff and just getting into the swing of things, is there like a very simple process to help people with their foreclosure issues after they're in the notice of default to be able to use exactly what it is that we're going to be taught here? Is there like some simple, easy way of ending the notice of default in the foreclosure process?
An easy. I think we're going to come down to pulling out the whole tree, and that way all the leaves of the issues, the problems in everybody's lives are going to end right there. And that's really what I'm shooting for, to get this workshop off the ground and get the documentation to prove the trust and make the claim and really terminate the whole account.
So for the time being, people that are in trouble with their foreclosures don't have no hope to stop that.
It's like we could try what we're doing, and I don't know how effective it would be. It'd probably be effective because it's still under the discretionary trust, and whether or not you have a remedy is per the discretion of the trustee, the U.S. bankruptcy trustee, whoever that might be. And I think the only way to really get a remedy is to, like, go after the roots and pull the root out.
Yeah.
Exactly.
You might have a higher degree of success trying to merge the titles and to start out with, but I think once they, they're going to go back to that IMF master file and say, hey, you're the trustee on this, and we're going to ignore what you put in, claiming you're beneficiary.
Mm-hmm.
How
you can always go back later after. I know it just doesn't help anybody now when they're getting thrown out of their home, but you can always go back later and reopen the case.
Going back, exactly.
Yeah, but in a mortgage, we've got so much tools just in straight litigation that I think it really boils down to it's the party that's doing the pro se litigation. They're their own worst enemies because they don't know enough. You could probably win just on straight litigation method with the tools we have available today. Except it's the people that don't know how to use the tools.
Yeah.
Because Mir's been effectively knocked out of the box by the landmark decisions and all those past cases. Mir's can't do a nominee assignment to anybody. That affects 63 million foreclosure cases, that are out there having to do with Mir's. So it's not a question of, tools, whether we have the right tools. It's whether or not they have the knowledge to use the tools.
Yeah.
How about commingling?
Yeah, 9-336, tying that in with the commingling, where the security agreement's been transferred onto the pool, the collateral, and leaves the collateral, yeah.
Yep, exactly.
Is that under the UCC, 9-336?
Yeah, 9-336 under UCC.
Okay.
Under the official comments, it really explains,
Hey, Christian, it's Chris Florida.
6 is 1, 2, 3, 4, 5, 6. So then it's talking about commingling goods down at the bottom. It says goods whose identity is lost by commingling with other goods from which they came. And under the number 3 comment, consequences of becoming commingled goods. By definition, the identity of the original collateral cannot be determined once the original collateral becomes commingled goods. Consequently, the security interest in the specific original collateral alone is lost once the collateral becomes commingled goods, and no security interest in the original collateral can be created thereafter except as a part of the resulting product or mass. So it's transferred the original collateral to the mass that they commingled it with, and they lost the ability to foreclose on the original. But how come they keep coming at it? Of course. Don't have the tools to enforce it yet, or we're not trying to enforce it.
So in other words, what you're saying, just from the language I'm used to, is once they've converted the promissory note into a security, they've commingled that with a different beast.
Yeah.
So is that what you're saying? Is because they've converted it into a security that they no longer have the ability or the power to foreclose?
Yeah, they split the title.
Uh-huh.
They split the title and lost it.
And they, for instance, with mine, the city mortgage, this here in New York, it's a judicial state. Now, I happen to see this little copy that they claim they sent me, saying that they have the original in the vault, in a vault, all the records in a vault, which I doubt because it has about 3 or 4 pages.
Makes no difference. Once they've securitized, let me read the next paragraph. Once collateral becomes commingled goods, the secured party security interest is transferred from the original collateral to the product or mass. They lost their security interest in the original collateral. If they come at you in a complaint that says trustee for such and such a trust, whatever it is, XYZ number that it got on there, they've commingled the funds, and they've lost the ability to foreclose because the security interest is transferred from the original collateral, the house, to the product mass, the securitized pool. And nobody can identify who the real owner is.
But that's only with a bank, not a private loan, right?
Yeah, private. I don't think
it applies to trust. Anytime you
it would apply to a second note from a private party that's a corporate entity that's a trustee.
If securitize the note, yeah.
No, but they don't. The private parties don't securitize the note.
Okay, well then it's not securitized. Then this commingling didn't occur under securitization.
Right.
Now, what is very interesting, City Mortgage claims that they're just a servicing. They claim that they are the servicer.
Oh, they are.
But no one said who the heck owns the note.
Right.
Yeah,
well, you got to put up the proof.
The international investors own the note.
Now, here's what I found out though. When I did get copies of the transfers, and they apparently transferred the mortgage with all the signs and everything to Jenny Mae. And then the next time I saw the transfer, Jenny Mae was the pooling, was the pool. It was in the, they put it at the top. And
commingled funds.
Yeah, but what was interesting, Chemical Bank transferred it to Jenny Mae in 1997. Then Chemical Bank transferred it to City Mortgage in 2000. But there's no record of a transfer out of Jenny Mae to anybody. So apparently Chemical Bank, who is now Chase, transferred it to Jenny Mae, then turned around and did a transfer of the same property, this time to City Mortgage, but there's a pool type at the top designation on it, and that's where it says Jenny Mae.
Well, the word transfer is commingled.
Special deposit, it shouldn't be commingled. It should still be held where you deposit it. And that's conversion. And you can come at them with conversion charges as a cause of action.
Because that bank is no longer in existence.
What? That's a conversion charges?
Yeah, conversion charges is commingling.
Now, Christian, what happens? What happens is the credit application to trust where they're actually securing funds before the notes are signed, so it's actually arbitrage.
Yeah, because the application was a power of attorney for them to appoint another trustea other than the bank.
And grab funds.
Because they had to have the funds before closing.
Right. So they get the credit app. They go overseas to international investors. They get the money. They actually have the money prior to even having the notes, the deed and the note signed. So that's arbitrage.
Yeah, but nobody's coming after them with any kind of charges or causes of action. And
I know that. I realize that.
But
there's an additional thing to this. If you go to the Federal Reserve Act and you look under the regulations and rules for consumer goods or household mortgages, it stipulates, or it actually says right in the law, right there, that the promissory note and the mortgage contract are to remain in a warehouse under security with insurance to protect it, and it's not to be removed until it has been completely paid off and canceled out. So if they are actually in violation to that set of regulations by the Federal Reserve Bank in order for them to get the credit, well, then that's a federal offense right there.
That's why AIG went down, because they were the insurers of these bundled mortgages that weren't in a warehouse.
No, I'm not so sure, fellas. Again, go back to page 127 of the trust manual. They're claiming to be the beneficiary, correct, on the alienability of beneficial interest, the beneficiary can transfer their interest to someone else, and that's what they're claiming they've done.
Corporation can't be a, beneficiary.
Yep. And it comes off the original collateral and goes on to the pool, though.
But Christian, can you get a Series 7 securities broker to run the lineage of the notes?
But really, if you've got a complaint that they're coming at you and it says in their trustee for such and such a trust fund, right there is proof on the complaint itself that they securitized the thing and they commingled the funds, and that's a conversion and a breach of trust.
Yeah, but that's if they're claiming trustee, but they're not claiming that. They're claiming you're the trustee and they're acting as the beneficiary, so they can then transfer their equitable ownership, if you will.
Yeah, their interest back in and establish as a grantor, straighten the parties up, and then do a reassignment.
That's the only way. Because as I looked at it, I said, this is what they're doing. They're acting as if they're the beneficiary, making you the trustee until they want to move on you. Then they want to do a switcheroo on you.
When they do the switcheroo on you, can you contest it?
Well, not contest. See who proves
you want to claim trust? You got to prove trust.
Yeah, and go and claim trust. And we didn't claim it. So the only way we got to claim it, we got to turn around and claim grantor status.
No, if you're the grantor and they do a substitute, because they always substitute the trustee when they get ready to foreclose.
I bet you don't have a document to say you are.
Say that again?
-10 statement of accounting, so I got a right to do a rescission on the power of attorneys and the signatures on that. And then I can come in and prove the claim on the trust with the trust proof, establish myself as grantor, reestablish the parties, and then merge the title in the bank because the beneficiary is the payee on the note, and then merge the legal title in the beneficiary, which is the bank. And now they're sitting there holding both titles, and the trust is terminated. Now they got to disperse the funds. And I could also come in with a recall on my note. I want my deposit back, my special deposit. If they don't give me my special deposit back after I issued an order to return my special deposit, they're in conversion.
They're in collusion or conversion?
Conversion.
Even if they brought the note back to trust, it has all those stamps on it, paid to the order or without recourse to 2 or 3 other people. That's not the note that you gave them.
Well, I think we need coming at them under trust law, not under anything else, not under debtor-creditor law. Trust law. Why did the U.S. come at SNEP with trust law when they had 2 signed contracts? Because the power of equity rests in once the beneficiary has made a claim against the trustee is presumed to be guilty, can't prove himself innocent unless he's got a record that he made a payment or distribution. Get him in equity, and you win.
Where can I do a little more research on this particular type of information that you're talking about right now? Is there any set of documents that you can send me to where I can actually sit down for a couple hours and just research it to kind of come to the same conclusion of what you're speaking about?
I can't think of the one tapes that we've talked about this in pretty in-depth. But I know it's, anybody have any ideas what the number of the tape is that we're talking about this?
1226.
1226?
Another thing, Christian, you said to go back in November, and on your new website, you only go back to 12. You don't go to 11.
Well, I've got 18 more that are sitting up there. I got to connect them onto the page.
Ah, okay.
But the 1226 is up on the page right now?
Yeah, 1226 is up there, yeah.
I think so, like 12.3 or 12.8's up there.
Yeah, well, I got 18 more coming, which takes it back to like 10, back into October.
When will you have that?
Probably this week sometime.
Okay.
Hey,
that's fabulous.
And for the guy that was just asking about stuff to study,
last night I asked Christian about some stuff that's been that I was looking for the source on, and on the second restatement on trust, section 341, 342, and 345.
Now, excuse me, just for a minute. Is that in the manual that he's recommended us to pick up, the Gilbert manual?
No, that you just find out online.
That was on
okay. Tell me one more time, because I must have missed something there.
The second restatement.
The what statement?
Second restatement on the law of trust.
Second restatement
on the law of trust.
On the law of
section 342, 341, and what was the other ones I gave? I forget.
345, Christian.
345.
Yeah.
Yeah. Also. No. Merger was
Christian.
Yeah.
Going back to the part, I really admire your insight into the area about how our word is our bond. When Moshe, so-called Moses, went up to Mount Sinai and he was on his second 40-day fast, back to the first 40-day fast, and he was given the so-called oral law, which was then brought forth by word through generation from father to son until they made up the Midrash and the Talmud, and then the powers that be in the area of so-called law then converted those into the uniform.
Yeah, the Jewish Shtar.
Are you follow that lineage?
Yeah, I did a whole program on that, traced it all the way back to Babylon through Israel.
Really? Where?
About a year and a half ago, when I started the show, or early into the start of the show, I did a whole show on the Jewish Shtar.
Oh, how can I get that?
To France and to Rome and to Israel and back to Babylon.
How could I get that program?
Send me an email and I put up in the caption there. I'd like to have that download from the Jewish Shtar.
Okay.
Yeah.
Hey, Christian.
Go ahead.
Oh. Hey, Christian, this is Eric.
Eric, go ahead.
Hey, I was going back and listening to when we were talking about doing the summons to get our private admin process done through the clerk. Now we would first file the counterclaim with the RA number referencing our private administrative process, because we wouldn't want to put that actually in the public. We would just use a number on there for reference. And my question about that is if we were to send out that claim after doing an administrative process and attaining a private declaratory judgment on a dishonor, what do you think the real chances of getting a response on that summons really are?
If they don't respond after you've issued the summons and paid the fine for the counterclaim, they only got 20 days to respond. If they don't respond, you got a certified default against them, and you just won.
I agree, but, based on the stuff that we're putting in our private administrative process as far as like a order for debt validation and how you've talked about that they can't respond to it because they interrupt the prescription, if that's the case, then how could they possibly even respond to the claim? Because they'll interrupt the prescription anyways.
Yeah. I mean, either way, you got them.
Okay.
They can respond. Yeah, the key thing is to file a counterclaim, pay the fee, and then have the sheriff issue the summons and serve the summons. Now they got 25 days, and if they default by not answering, you can go to the clerk of the court and have the clerk certify the default. You don't need to go to any judge.
Under the Rule 55?
I don't know where it is in federal, I forget, but yeah.
Yeah, that's it, Rule 55.
Yeah, that's default. Yeah, 55 is rule default.
Mm-hmm.
Yeah,
55B.
Verify a default under the summons.
Christian, I have a question about this. Is JC.
Yeah, go ahead.
Eric, can you clarify that? Because I know we talked about that before, but at least as long as we're all here on the call.
Yes.
I want to make sure that we're all clear between the claim and counterclaim. So you ran the administrative process and you created a notary default, correct? So now that's your claim. You keep talking about a claim and a counterclaim. What are you going to do with that notary default?
Okay, if I'm in a case, it's going to be a counterclaim because I'm going to use that as to come back in and hit them with a counterclaim with.
Right, if you're already involved in a case. So they've already come at you as probably the plaintiff, you maybe before or after you answer with your response of pleading, you run the administrative process. That's fine. Now you can bring that in. You can do a counterclaim in breach of trust if you actually turn that notice of default into trust res and then move that. But and that's also another you can have a counterclaim with that. But if you're not in court already, what are you going to do with that? You have this counterclaim. You have this claim, this administrative claim that's run and done on the administrative side in the private. How are you going to bring that into the public?
Okay, then I'll come in with an independent action, creating a claim, come at them with a claim in court.
Now you're throwing me because the counterclaim is attached to the original claim. But if you're going to go in and get a whole new...
There's not a court case going on already.
Okay, so that means you
actually not going on.
Whole new...
No, that was my point. And that's why I asked Eric to clarify, because I want to make sure that we're on the same page here. Just assume that you've run the administrative process. You put somebody into default, whether it's a credit card company or the IRS or somebody. So you have that notice of default now, but you don't have a court case. That's just an administrative process that's
you
done.
You need a DIB hearing.
Wait. So you need a DIB hearing, for example, for a mortgage situation, you need a DIB hearing?
Yeah, you need some kind of DIB hearing to bring the evidence in on the public side and get that public recognition of that record.
Don't tell me
So then, to do that, then just go in for a declaratory judgment then.
Yeah, you could do that. Or I could do a DIB hearing in the IRS and do it administratively up there in the Treasury.
Okay, couldn't you go to small claims court since you don't have a value on it? You're basically going to go into a small claims and see if you can turn it to a declaratory. Just put your evidence there and get that judge to declare what the law is.
Well, I don't think this would be small.
What is it, $5,000 or something?
I think it's $15,000.
Small claims is the cheap way out, but he's a judge and he can do that because all he's going to do is look at the evidence.
But not on a mortgage.
Yeah.
Why not?
Yeah. I don't know about a mortgage.
You're just making you are declaring. Remember, you're getting him to go on your process.
Yeah, but I think we get too much on debtor creditor. We want to stick more towards the trust and.
Mm-hmm.
Yeah.
I agree with that, but I'm trying to get some clarification here.
Right, and Kristen, you talked about bringing so you have calling a DIB hearing on the independent action or actually just on the administrative commercial claim?
The DIB hearing on the... Well, that'd be both
right,
one and the same.
On court case, so you've run the administrative claim, that's done. You have the notice of default, and now you're talking about running, or you need to call a DIB hearing.
Yeah, I need a DIB hearing, yeah. You're either going to call a DIB hearing, say, in court, or I'm going to do a DIB hearing with the IRS.
You wouldn't just file an action in court, in your local county court?
Yeah, you could do that. That's a DIB hearing.
Okay, I didn't know that was a DIB hearing.
Yeah.
Is DIB an acronym for something else?
No, Data Integrity Board hearing.
Okay. But is that something your local county court judge would handle, would be a DIB hearing?
Yeah, he handles DIB hearings all day. That's all he does is DIB hearings.
What will be your cause of action, Christian?
The cause of action? Well, I could come in with a breach of trust. Breach of fiduciary duty.
Right.
Breach of fiduciary duty would probably be much more what they would see on the colorable side, right?
Yeah, breach of trust, breach of fiduciary duty, same thing. Cause of action, conversion, they commingle my funds. It's all the same thing. You know, they're all leading. You know, it's just like you break one of the law, you broke them all. They all fall down.
You know
they
what?
just
Well,
fall in a sequence, one right after the other.
all right. While we're on this subject, why don't we go ahead and list once and for all the causes of action, so then we can start looking into putting together pleadings with all those causes of actions.
Yeah, first would be the cause of action would be, you know, breach of fiduciary duty, because the trustee, breach of trustee duty. Now that's the same almost as breach of trust.
Conversion, right? The next one?
Let me get to the section here.
So it's breach of trustee fiduciary duty?
Yeah, well, breach of fiduciary duty, breach of trustee duty, same thing. And then breach of trust.
Say again, breach of what?
Breach of trust.
Breach of trust, okay.
Where are we at here?
Well, you also mentioned commingled good. You mentioned that earlier, that would be a cause of action.
Yes, that's one of them. Oh, here we go. Here's the section.
Did you say capacity as well?
5. Starting on section 227.
What are you looking at again, Christian?
Gilbert's, page 65.
Section 227?
227, right.
All right.
228 is frauds on creditors. Now, I'm kind of like looking at this in reverse, though. Number 1 is the effect, and then the effect is, let's see, fraudulent transfer, unfair business practices. Now, unfair business practice takes in A, fraud, B, misrepresentation, and C, unconscionable acts or practices against the consumers.
Slow that one again.
Okay, A is fraud under unfair business practice. A, fraud. B is misrepresentation. And C is unconscionable acts or practices against consumers.
What about concealment?
Yeah, I mean, I think you can come up with, but I like to stick with the main ones that they're used to seeing colorably.
Yeah.
Then under 29, you've got unclean hands as a cause of action. And then under B, under that section, you have unjust enrichment.
Can you slow down?
Forward again. 229 is causes of action would be unclean hands. And then under B is unjust enrichment.
So you can't when you use the trust law technology, you don't think about creating a lien against them?
No, the lien is.
This follows the same as the lien falls under alienability in Gilbert's, right, Christian?
Yeah, under statutory. Remember,
So when you have a notice of default, then you go for these things that we're discussing.
Yeah, but I really don't have to create a lien because I'm talking about a specific trust res, which is a thing, and there's no value on a thing.
But why do you? I mean, isn't there a way of handling it without going into court?
Yeah, you could go to Treasury.
All right, back up.
Under 25-06, Treasury Directive DIP hearing.
All right, so let's break this down. We finish our administrative process. We're holding the notice of dishonor in our hand. So then we don't even need to go to court. We just go ahead and send in the documentation. What is it, an application for a 2506 hearing?
Well, it's not an application. The application is you're asking to be the debtor under an application.
All right. You do an order?
You do an order. You do a direct.
You do a directive. So then we would send that in to what, the IRS?
Yeah, Treasury.
The Treasury.
Would that be U.S. Treasury?
Treasury Directive 25-06.
Oh, direct. Okay.
Directive. Treasury Directive 25-06.
And so what takes place at that point?
They're going to do the DIB hearing, because that 25-06, that's a directive for a DIB hearing to correct the record.
But that's only if we've already got our IMF updated properly, right?
Well, now in this instance, we may be thinking about correcting the whole file under a Treasury Directive 25-06, but in this individual case, like the leaves of the tree, and this particular issue, a DIP hearing without going into court, we could do it through the Treasury again.
But that could only be if we have our IMF updated, right?
Yeah, you may have the greater success with the correction of the master file first.
Yeah, because if the master file says that we're the trustee, they're going to say, wait a minute, we don't have any business dispersing funds.
What about if you're trying to help somebody else and, they're not up to date on the IMF being updated?
Well, I think we better understand it ourselves first.
Mm-hmm.
Yeah, really? Well, for example, I sent out a notice of dishonor on an administrative process today. And I'm trying to figure out if it's appropriate to do the DIP hearing at this point, or if I'm better off to file an action in the local court, or just stop paying the mortgage and let them take action against me.
Well, I like coming at that maybe first. That way, before it gets into this garbage and stuff and claims in court, maybe I could get it settled before it even gets into court.
You mean with the DIP hearing?
Yeah.
Well, I'm not so familiar with the DIB hearing side. Would maybe I can send you an email privately, and we can do the paperwork for it?
Possibly.
Okay.
Let me go back to, I'm saving the big one for last.
Antitrust.
Cause of action after all that was really the unfair business practices that these banks are coming against you with, because they've got their teams of attorneys and you are at a disadvantage, and they are creating a monopoly. And a monopoly, look at it in Black's Law, it's any time
Absolutely.
That is antitrust.
Absolutely.
That is the big hammer.
I've got a whole bunch of work I've been doing on that recently. Huge. I have a huge file building. That is the big one.
So you've got a trust, and they're coming at you under a monopoly, and they're coming at you under antitrust. And that is protecting commerce against consumers, and that is an unfair business practice. That's a monopoly.
So if you had 2,500 mortgages that you could do a trust law process on and an antitrust violation, is it possible?
Yeah. But you don't need
I have a potential 2,500 more. Huh?
You don't need 2,500. You can do it with one.
Yeah, but if you did it with 2,500, it would be a major impact.
Either way, it's going to be major, because antitrust is a big thing with the banks.
Well, they've got nails already on it. I'll send you the cases.
Yeah, well, but antitrust is the big hammer.
Oh, yeah.
So what do? You just go ahead and file like a cause of action that they've monopolized and they're using unfair business practices, and therefore they're in violation of the antitrust laws? Is that kind of the sizing it up?
Yes. You want to look under the let's see, which one is it in you?
But if you can get a securities broker to find the lineage of the paper from the credit application and prove that they had the funds before they had the signature on the mortgage note and the promissory note, you would have to have some kind of proof.
Yeah, because anybody who makes a claim has to have proof.
Oh, that kind, yeah. If you're going to come out like that, because, I mean, if you go antitrust, that means you're going to have the whole country.
Well, okay, now that's very interesting.
Now we're talking about trust now, not the rest of the country. Let's talk about trust.
Okay,
trust and antitrust. If they have a monopoly and they've commingled your deposit and they breached the trust, and you have an unfair advantage because they're forcing you to sign contracts that you don't really understand and know, and they've got teams of attorneys on their side and you don't, then you got an unfair advantage.
Yeah, but it's not just that. That's just the start of it. They're holding a monopoly on the price of real estate going up and real estate going down. So you have an unfair industry practice.
Based on an unconscionable contract because they're trying to get you under debtor creditor continuously, and here's a trust, and you never expressed the trust. And here's antitrust all along.
Well, also they're expanding the credit and contracting it, and it's affecting the prices. They're manipulating the prices.
Right, for value.
Yes, that's the big one. That's where you get the whole country in on it.
Yeah, but I don't think you're going to make that stick.
You never know.
And that's the whole purpose of the Federal Reserve System. That's exactly
you actually have the Federal Reserve on the hook at that point.
Mm-hmm. Well, that's always been their stated claim, their stated purpose. So, and the judiciary never went after them at all in their whole history, and they put that right out there.
Yeah, but now you have nations that have been stuck with these mortgage-backed security pools. They're claiming that it's homes. It's probably most likely prison bonds, etc. But they're reneging on paying them because they were fraudulently brought to them, and now you have corporations internationally that are reneging on paying on these pools of securities, and then you have us down at the individual level that are refusing to pay them.
Yeah, but let's stick with the
They won't go to war against the country, but they'll beat up on you, though. Bet on it.
Right.
Christian, can we break it back down to the TD 2506 again?
Yeah, let me finish up with the antitrust. The antitrust is anything against the furtherance of commerce or anything that impedes or monopolizes commerce by a lack of economic competition.
Right.
That's antitrust.
Lack
of economic competition.
Economic competition.
Is that out of Black's Christian?
Yes.
What edition?
I forget. Probably the 8th.
Okay.
It's impeding or monopolizing commerce by a lack of economic competition. That's antitrust. That's monopoly.
Yeah, and that's exactly what they're doing.
Yep.
So how do we hold that, like he said, back down to level 1? How do we proceed with activating that right there, the antitrust on a one-house level?
Well, there's your causes of action. Put it in a pleading, which is your bill in equity.
Well, this brings together something very interesting. You ever heard of a purchase money mortgage?
Yeah. Mm-hmm.
Okay. Mine is a purchase money mortgage. I didn't realize it. It was done initially out of the secondary mortgage market because it's a very old house, about 25 years ago. It was a purchase money mortgage, so it never went to MERS. But now, by its very definition, I can't close. They're claiming that they lent me money. I purchased.
Yeah, but let's off debtor creditor stuff and stick with trust.
Yeah.
Because there's no way that they can get out of that. If they gave me what's by the definition of a purchase money mortgage, I can't get to closing unless they've already given me the money.
Yeah, but I'm not really concerned about that. I'm concerned about trust. Let's think trust, because we want to get them in equity where the trustee is presumed guilty. And the only way he can prove his innocence is if he's got a record of a payment.
Okay, now,
and that's going to be the same for a second note holder as a first, whether it's a bank or it's a private corporation.
Treat it as a trust.
Okay.
Treat it in trust.
Now It is a trust already. You just have to express it to be a trust.
That's my point.
Already a trust already. You just got to express it as a trust.
We express it, in New York it's expressed as a trust because it's a mortgage deed of trust. However, they're claiming beneficiary status.
Prove that you're grantor and change the parties. Come in with the reversion, the rescission of the signature and the power of attorneys. That you gave them power of attorney to do the appointment and the redoing everything.
And do you have to do something before you do that?
Move the title.
Honor by notary presentment under the 9-210, which is debt validation, basically, because I'm going after the certificate. The certificate is honored.
What's the minimum amount of days you could do the debt validation if you've got a notice of sale in 2 weeks?
Well, I could do a debt validation probably in about 7 to 10. Oh, excuse me. The debt validation, that requires 14 under 9-210.
9-210?
It's 14 days, yeah. Excuse me.
Okay.
Christian, if you did a order for debt validation and added in a self-executing power of attorney,
right?
Could you go ahead and do the work that you were stating about a minute ago? Instead of giving them power of attorney, you get power of attorney and do that.
Well, all I got to do is state that I'm a grantor, and that's what I got. I am the grantor. I'm going to change the party.
But can you, with the debt validation in the 17 days, you can put in self-executing clause in there that you're the grantor?
No, that you got power of attorney to do the work you need to do.
I would want to come up with the actual proof that I was the one that created the records on a present transfer of trust property sometime. That's the proof I need. I need a record of that.
So walk through it. You get debt validation in 7 days.
14 days. 14 days.
I mean 14 days. Excuse me.
And they'll give you a map.
The application that you made originally for the mortgage escrow closing application they took that application, which was a power of attorney, and since they're the beneficiary of the bank, now they can't be trustee. They know that. So what they did is they got you in a power of attorney so they could appoint a trustee, and they appointed the escrow agent, the title company, to be the trustee.
Mm-hmm.
So they bank and they can't be beneficiary and trustee at the same time because the trust would terminate. So they knew that. So they got you in a power of attorney for you to appoint, give them the power of attorney so that they could appoint Mr. Title Company to be the escrow closing agent. I needed something to colorably come at them and say I got a reason to rescind that power appointment. And I used that 9-210 in an administrative process to get them in a dishonor that gives me the ability to rescind that power of appointment.
They move against you already?
Say that again? What?
Have they moved against you in any way already?
Yes.
They may have. They don't have. I mean, I could set this up and change it all around without being in default of anything.
Okay, but even if they moved if they came at you already on a foreclosure or any foreclosure action, you can go at that point. You can rescind your signature because number one, they failed to give you the correct beginning balance. The beginning balance should have been 0.
Yes. Also, under the 9-210A4, it states that if I put an amount in there, which I'm going to put 0, I owe 0. If they don't respond in 14 days, that's validation that it's 0.
That's good.
And they never respond back to this. But the whole point is, and if this was done by notary...
But does a private party respond to it?
No. They may. I don't know.
But Chris, you were saying if this was done by notary presentment...
Dishonor certified by the notary, because that certificate of dishonor by the notary is what's going to give me unclean hands doctrine.
Yep.
That's good.
But now under equity, Mr. Bank can't come in to a court of equity and ask equity to foreclose on me, if they themselves aren't doing equity. If they've got clean hands, they're not doing equity. That means I can get it thrown out of court because I got a certificate certifying that they have unclean hands and they can't ask equity to foreclose on me.
But Christian, the only way you're going to be able to get your private process with proper judicial notice is if you get in chambers, correct?
Yes.
Okay.
Well, this is.
Can you repeat that? Repeat that.
On the colorable side, and the certificate would be in chambers.
Right.
So how long does that take?
14 days for the statement of accounting under 9-210, and whatever it takes to get it certified and the actions and stuff put together.
And then to get it in chambers hearing.
Yeah, then whatever it takes to get it in chambers hearing. But see, with the unclean hands doctrine, that sets up the ability to come in with a temporary restraining order or a preliminary injunction stopping all actions in the case.
Ah.
However, you keep mentioning, one of the guys keep mentioning a private party, not a bank.
I didn't say a private party. I said a private administrative process.
No, somebody mentioned.
No, I said private party. He's right.
A private party. Now, when you're dealing with a private party, that's a different animal here because they're not engaged in that conversion.
All right. Well, do a second process on them as the straw man entity, which is another fiction.
Sir, do you mean like as if you had a private mortgage holder instead of an institution? Is that what you mean?
Right. Correct.
Do a debt validation against them under the fiction.
Right. Now, Christian, we were talking about all the causes of action. Did you get through all those, or do we? Because I was wondering about
the class, which was the antitrust. So I was all through with them.
What about commingling and conversion?
Yeah, well, those two in there I didn't put in there. Yeah.
Okay, so what you got is unfair practice. I'm sorry, breach of fiduciary duty, breach of trust, commingling violation, UCC 9336, unfair business practices, fraud, misrepresentation, unconscionable acts or practices against consumers, unclean hands, unjust enrichment, creation of a monopoly, and antitrust.
Yeah. That's enough, isn't it? Yeah, you only need one. I hope I didn't read it too fast for everybody.
Now, Christian, if we go ahead and go on the colorable side, all these causes of action, if we go ahead and put a complaint in or a pleading, it's up to us to prove it up, and is the way that we're going to prove that up is in chambers with our private administrative process that we did. That's going to be enough to prove it up.
You don't get it unless you request. Hold it now. You just don't automatically walk in chambers.
No, I understand that, but let me get my question.
A protective order, get it in the chambers.
I know.
That's how you get it in there.
How? Protective order.
You go in and request a protective order.
Protective order sets up CCI information or trade secret information.
Right, and your rules of civil procedure in your state, they would all have it in there.
Yeah, I'm aware.
Okay.
But back to the question I was asking is, once we're in camera, is that enough to present the private administrative process? Is that enough to prove up my claim?
Man, you got so much stuff to throw up against the wall, something's bound to stick. It's like throwing crap at people. If a little bit hits them, they're going to stink.
Well, as long as you got two records to prove any fact.
You can prove.
Two witnesses, two records to prove any fact.
Okay, so in this situation, the notary would be one witness, and I would be the other witness of the private administrative process that they failed to respond to on the debt validation, for example?
Yeah, true. You and somebody else, yep.
Me and the notary.
And if you file it in a UCC 1, that's a third witness, public witness.
Yep, and it's outside the hearsay rules. It's the exception.
So as far as the UCC 1, what would we file on the UCC 1 for these causes of action? What would we put on there, for example?
Well, those are your notices again, so, you know.
Yep. What I did is
private documents again, additional private documents.
I'm sorry, repeat the whole thing, Christian.
Set up your UCC as a notice is against your private documents, another new private record you're creating.
Does it become any more powerful the more witnesses we set up?
I think, the Scripture says it takes 2 or more.
Yep. 3 is great. Now, if you could have God walk in there with you,
and then to get all the proper elements for these causes of action, go to the Bender's book over in the law library. Would that be the best course, you think?
Either that or go to the law library and just pull up those causes of actions. Because that'll give you the elements under each cause of action, and you got to have the elements under each cause of action.
What, JC?
I was going to say that certificate of dishonor, that's your title.
Your trust res?
Yeah. That's your judge. That's your
so again, you have 2 ways to do it. You can call it dib hearing, and my question to Christian is there's a bunch of different people that sit on the board of the TD of the dib hearing that are permanent members. So one is, to whom would we send the demand for correction of record? If you run an administrative process, you end up with that certificate of title, the notice of dishonor. And that is, of course, if you want to keep it in private and just end this before you end up in court, do a dib hearing, and maybe they'll correct the record, maybe not. And the second way is, of course, turn that title into trust res, and then you can bring that in through cause of action when they breach that. But then you have to move that. You have to take that and run the entire process through moving titles, so that then when they default on that, then and they don't correct the record, then you can claim breach and all the other causes of action under trust.
Under trust, right? And that's the big thing.
So let's go back to the dib hearing. What kind of document are we going to file to the board?
What kind of document to the Treasury Director Board?
Yeah. It's going to be an order?
Yeah, it's an order, a directive.
And what kind of directive or order is it going to be?
I have an example of a letter that was sent. It's pretty basic. You just, instructed them to do a dib hearing and correct the records, and you present your records up there.
Can you just, like if you've got them in a UCC1, can you just have them referred to the UCC number so they can go look at the contents?
No, I'd want to, furnish them with all the information that I could.
Yeah, don't make them hunt for it, just like a judge won't, right?
Right. Present the information.
Oh, okay.
Now, is that dib hearing, is that public or is that private?
That's a private administrative dib hearing, yeah.
Are all dib hearings private administrative?
Yeah. Well, this is the private side of the Treasury, so you might have some in the court. A dib hearing in court, you got a public dib hearing, you got a private in chambers dib hearing.
So you got to know where to send it and how to send it? Sorry, Jason.
Yeah, Christian, that was my other question. Is to whom in the Treasury we're going to send that for the dib?
Okay, I have an old name, and I'm sure it's been replaced, but there was an entity or a party that you specifically request. I forget exactly who it is now. I have an example document.
Can you send that, Christian?
Yeah.
Yeah. LearnLaw at Comcast.net.
I'm trying to get all this stuff on the website.
Oh.
Accessible to everybody.
If that's an old name, any idea of what path we might want to hunt on to get a more up-to-date information?
Location would be more better.
Yeah, I believe that the address was, where was it at? 1500 Pennsylvania Avenue, yeah.
Yep.
Oh, so it went down, okay, it went to...
But to what title? When you read the TD 25-06 under membership, it talks about the Office of General Counsel as a permanent member of the board. I mean, you could send it to, for example, any one of the permanent members of the board, which include the CIO, the Inspector General, and the TIGTA.
What will we just stamp the outside of the envelope confidential, private, or something like that?
Yeah, one guy gave an example. Put the envelope in private inside another envelope marked private.
Okay. And then what? Do a cover letter to give them the nature of what it's all about.
Yeah, you have to explain to them, what you want, what you're presenting your case, basically.
Okay. That was kind of a question you had recently, wasn't it, JC?
Yeah, well, under Section 2, the CIO, Chief Information Officer, who is the senior executive official responsible for the Information Resources Management Program, shall serve as chairperson of the DIV. So it seems to me we could just address it to the U.S. Treasury, CIO.
No.
We just got to make sure we got a current person, right?
Mm-hmm.
On this dip hearing, when we go before dip hearing on dealing with correcting the record about your status, now you're going in, you want to correct your status from that of trustee to grantor and beneficiary, or just grantor? You're going to correct all of them. Is that?
Hold on, I'm trying to pull up this document.
Sir, from my understanding so far, we're going to want to be grantor and beneficiary because we never want to be trustee in court. And then if we're outside of court, if we're beneficiary, we'll be able to pull funds from the private and pull it over to a bank account on the public side, and nobody will be to the wiser that we're pulling it from the private.
I'll tell you one of the reasons I asked that, because when you're starting to deal with looking at the whole issue of trust in their code, they make the beneficiary tax the one responsible for tax.
But on the private, we're not responsible for, as long as we're not effectively connected with a U.S. trade or business, where taxes are not an issue for us.
Okay. All right. I was just curious because we're going to express ourselves as a trust, and the beneficiary and the trustee is the one who has to pay the taxes on distribution.
When you guys, all you guys must be like originally debtor-creditor guys.
Used to be.
Right. So
I'm going to withdraw.
Huh?
Going through withdrawal thing.
Okay, but my point is that you guys probably have a lot of friends that are debtor-to-creditor type people, right?
Don't we all?
I don't. But my point is that there's kind of it's like somebody that owns a house and it's gone down 50%. They can't hardly believe it's going to go down another 50 to 90% in the next 2 years. So they're a believer that where they're at is where they're at. Same with debtor to creditor guys. If you try to approach them and shed some light in the area of trust law and how debtor creditor is the wrong direction, you're going to have an argument. No?
Oh no! Don't get me wrong. I'm not arguing. I want some clarity about the fact that when I go to a dip hearing, I request that 2506 dip hearing. I want to correct the record that IMF filed. I want to go in correcting it. Definitely, I want to know if I'm going to go in to correct that record to grantor or grantor beneficiary, but definitely not trustee. Now, which one is it? Grantor beneficiary, grantor. Beg your pardon?
Christian?
Yeah.
Go ask Christian, please.
Yes, that's all I wanted to find out.
Well, Christian, if you're still looking stuff up, I know the answer.
Okay, go ahead.
Go ahead.
All right. Grantor beneficiary, because the IRS is going to handle the books, and they're going to make the payments that we need for them to make. Because the trustee is responsible to keep the books.
How can the trustee...
Has anybody filled that form out, that 2506?
This is what Christian's right.
Oh, that's the sample he's looking for?
Yeah. Yeah, I've got a notice and request here. Treasury Data Integrity Board.
The lady was saying something?
Ira L. Hobbs, but I'm sure that name is no longer valid, probably. 1500 Avenue, Washington, D.C., 20220.
Ira Hobbs?
Yeah. I don't know who that would be now. I'm sure that party's probably gone.
HOBBS?
Yes. Mm-hmm.
Christian, have you corrected your IMS thing in this manner?
No, not yet, no.
Why not?
I really haven't had enough time.
Oh, okay.
Put everything together and come up with a package and explain it and really putting it in for the workshop and, do it all together.
Uh-huh. Okay.
Christian, I have a question about the DIB. If the IRS is the DIB, how can the trustee and the DIB be in the same person?
Well, the DIB, there's many hands in the IRS. There may be, people that are designated for doing these hearings. I mean, DIB hearing is kind of a generic term. You can have a DIB hearing in court, DIB hearing out of court. You can have private administrative. You can have it in Treasury. A DIB hearing is just some place you need somebody to be an officiator or an official so that they can give you some kind of, public witness.
Okay, in that case, you might want them to be doing the transfer for you. I mean, would they have ever, in any case, if whatever they determine, then could you take that determination?
Well, see, I don't want them to do the transfer. I just want them to give an official stamp on the transfer and make sure that the records are corrected.
Okay.
Because I've already, maybe prior to that, already done the merging of the titles, and it's already done, the transfer has already taken place.
Well, I like that question that gentleman had about if your certificate of protest is really the res, how are you going to treat it?
The certificate of protest could be the res, yes. And how are we going to treat it?
Yeah, how are you going to treat? I mean, you're going to probably have that. You're going to have the proceeds of that in your UCC, but you can't really do a transfer. I'm just wondering if that's your.
Well, not at the fund, but I'm doing transferring of the title.
I'm sorry?
I'm not going to do it, say, a transfer of the value of the thing, but I'm going to do a transfer of the title.
Okay, but you may only have the proceeds of the certificate. You don't have the title to the certificate. The title of the certificate belongs to the notary. The notary is the one.
Yeah, the notary certificate, he's generating you under his hand and seal. He is certifying some kind of act.
Right. He's certifying that the record is true, correct, and complete, or whatever.
Yeah, it's a package, so it's what's attached to that he's certifying.
Right. So you can have we have the rights and titles and interests to the stipulations therein, and so on and so on. Is that what you mean?
Mm-hmm. Right. As a package.
It's the security agreement, basically, that we make with the other party, that we're going to own title to those, or we're going to hold title to the agreement, the stipulated agreement, and that should include trustee appointment and things like that, right?
Yeah, it could also, yeah, trustee appointment.
So then that would make us the beneficiary. That's how you in terms of transferring title, you want to get, as soon as you're transferring funds or something to pay an obligation, then you automatically are not they become the beneficiary in order to receive that, but then as soon as they
trustees of dispersing funds to another third party.
Yeah, that part I'm not clear about that part. I've never written anything like that, so I don't know how you would express that was their. I've only gotten up to the point that they don't do anything.
Right, because probably they don't do anything because we haven't come at them under equity.
Right.
Equity is like my big brother, like that's going to be the one who's going to be twisting and breaking arms.
Oh, that must be the Tin Man then.
Yeah.
Hey, Christian, it's JC. I have a comment about your Ira L. Hobbs.
Okay.
My earlier comment on the TD 2506 states that the chairman is the CIO, and in fact, on May 27, 2004, Ira Hobbs was appointed as the CIO of the Treasury. So that comports with to whom we should send that.
Okay.
So probably as a department, whoever is a CIO will receive that.
Let's see, on document says, pursuant to federal law, Treasury Directive 25-06 and 16-4 et al., the undersigned served notice and demand to respond that if, in this case it was a bill of exchange, is ignored or rejected, that they were then required by law to submit all confidential commercial information, CCI, in this matter, including the unprocessed bill of exchange, to the authorized Treasury Data Integrity Board, the TDIB, for investigation and review. So in this case, instead of a bill of exchange, you'd be putting in there the order to merge titles, or your certificate of deposit, say. So it says 5, the law and the Treasury directives require that the accounting records of the respondent match those of the Secretary of Treasury. The respondent apparently holds that this bill of exchange honored by Secretary of Treasury is invalid for discharge for their claim in opposition to the U.S. Supreme Court determination that such document acknowledged by the Secretary of Treasury without dishonor is valid tender in currency and serves to discharge claims in the private and public sector. This whole one document is geared towards debtor-creditor, and then we'll have to change this around to trust.
And is it invalid to discharge because discharge is on the public and offsets on the private?
Yeah, we would be using an order to discharge on the public side, set off on the private.
But in that text you were reading, it said it's invalid to discharge.
Yeah, that's what they're saying in this document, yeah.
Right, and my question is the reason it's invalid to discharge is because we're trying to use a private process, and it's set off in the private?
Yeah, I think that's what they were trying to do with the bill of exchanges and things, but really the bill of exchanges is totally on the debt side and really never touched anything on the private side anyway. So altogether, we thought we were doing discharges and set-offs, but all we were doing was just a discharge and putting it into the future and never paying anything.
So is that why we're not getting any remedy with the banks with the bills of exchanges, because we're doing them privately and they're really on the public side?
No, I think we're doing them publicly, thinking we're doing them privately.
Okay.
If you gave that to an Internal Revenue Service agent, he never sent it back. They converted that instrument. Then you should be, according to UCC.
That's under debtor-creditor again and at law, and there we are as being the debtors anyway, and we're under discretionary trust, and they got discretion whether or not they can honor anything.
So if you get the dip hearing, it's just another bite at the apple. In that respect, then.
That could be.
And just for everybody's knowledge, a DIB hearing doesn't necessarily mean that you're going to be standing in a room with other people. Christian explained to us recently it could be just that you send in documents and they evaluate them.
Yeah, that's all you would want them to do anyway. I don't think I want to go to Washington.
Yeah, it says the undersigned here and submits this request to the DIB to investigate, compare accounting documents, and determine whether or not any written dishonor by the Secretary exists, and to send a copy of the board's finding to the undersigned as soon as possible.
And the undersigned being?
Whoever is sending this up to them.
And there was probably
whoever's calling the hearing.
And there was no dishonor sent, because they usually just don't talk to you at all. So he sort of wins either way. I'm in that boat where I had a instrument. I attended a debt of credit instrument. I got a notary protest. But I didn't know what to do to follow up on it.
Right.
But just getting the record, getting them to correct the record. And that's what he tried to do.
So it says, in conclusion, as addressed to the applicable Treasury secured party, understands that the TDIB is to provide a determination report whether or not the respondent's records match the accounting of the Secretary of Treasury or the absence of their records. A notice of default will be issued. It's about 11 different points, but like I say, it's strictly debtor creditor, but yet, we can modify it.
Michael Duffy is a CIO currently.
Michael Duffy.
So is that our target, JC?
I think he's a document recipient. He's a CIO, and he's a chairman of the DIB. And I think he should receive all the documents in private.
What was his last name again?
Duffy, Delta Uniform Fox Yankee.
Boy, that sure is a serviceman talking.
I'm not sure what you're talking about.
Yeah, right, exactly, right. Hey, because we're finally getting down to where we might want to send this, we ought to probably all work together as a group and one person send one thing in and see what our response and what kind of results we're going to get based on the way that we send it and who we send it to, instead of everybody sending it all at once and we get mixed results.
That's a seminar right there. That's what it's for.
Why do you think that the chief information or operations would have the records?
With the manual.
When you read the text of the TD 25-06, it states that the CIO, Chief Information Officer, is a chairman of the board.
Okay, but wouldn't the CFO be the one?
Nope.
No, the Chief Information Officer of the United States Treasury.
Oh.
That's the person who's responsible for all the records, and that's what we're trying to get to, is alter the record for our advantage to show that we're the grantor.
So in actuality, we're going to express the trust to these guys.
Yep, because all records, according to the U.S. Attorney's Manual, must comport to the IMF.
Right. Under the U.S. Attorney's Manual 6-4.010.
Christian, you remember a few weeks ago I sent you what I've been looking at, this widely held fixed investment or fixed income trust document. That you
I haven't looked at it yet.
It said needed work. Okay. It used references that out of the Title 26 to establish trust interest holders, who they were, right out of the Title 26. Would you be using some of that type of references in the establishment of your position to the DIB?
Is it making reference to the beneficial owners?
Yes.
As Foreign Simple Trust?
Well, actually, in a sense, is it one of those fixed income trusts that they call themselves having?
Yeah, because with Foreign Simple Trust, Simple Trust is tying in with what we've been reading in the old treatise on the law and trust from 1888. And that's the same thing that they're using on the 8 bins on the instructions there as definitions of beneficial owners as being the, Foreign Simple Trust.
Okay, that's on the birth certificate side there. Foreign Situs Trust.
Yeah, but the Foreign Simple Trust would be the living man, the real entity.
Okay. And that's why you tie that to the Declaration of Independence.
Yes, right.
Okay. I did get the application to get a certified copy of that for $30 out of National Archives.
Right.
We will send a certified copy of the Declaration of Independence. So anybody who wants to get one, that's where you get it from.
Yeah, we did quite a bit of research on that. We actually been talking about the best way to approach that, because not only do we want to all sign that by accommodation, in other words, by power of attorney, send it to one person, but we don't want to send a bunch of different Declaration of Independence for the same reason up to Hillary Clinton's office for an apostille, because we're concerned that they might get wise to what we're doing, and then get us to maybe stop sending stuff to them, or stop doing our apostilles. So,
if you get it certified from the National Archives, then they can't refuse that.
Yeah, but they could still refuse to do the apostille if they catch on to what we're doing.
So how you want to approach this?
We were talking about all signing the Declaration of Independence by accommodation. In other words, one person has it, and then you send them a power of attorney where one person could just sign our names on that as signing parties to that one DOI and do it a launch.
Okay, and
why can't you just go to a different country for an international apostille instead of the U.S.?
Because the Declaration of Independence was done in the United States of America, not another country.
Yeah, but the international apostille is not under the United States law; it's under international law.
Yeah, because it's going to the IMF, and Hillary Clinton is the one that is our agent to do that.
They have a treaty of the United States; they have to accept it. I've already done it in 4 countries.
Where'd you send it to?
I'm Israel, Russia, America, and the nation of Hawaii.
How long was the turnaround time?
Depending on how much you wanted to pay.
Isn't that always the way it is?
Yep. They have
Well,
about three different ones, you know.
What were they?
Well, you can get them next day if you've got, dough. Elsewise, 30 days or 2 weeks. You pay this much, this much, this much.
But you got a foreign country to certify your record?
Yeah. I just got one of my kids dual citizenship without any records. First time I think in the history of the world.
Well, it's a pleasure to have you on the call.
Thank you.
Something I'm sure we're all interested in, but maybe we'll talk about it another time.
Oh, it's very interesting.
Now, I want to go back to this allonge. The way you want to handle this, then, is at the conference and have everybody who's going to be taking the course get together and do a one-time good, a one shot.
Well, we're never all going to be standing in the same room. What I'm saying is that when we get ready to sign the allonge, everybody signs a power of attorney or sends a power of attorney to the person who has the DOI, and then they just have one person sign our name by accommodation.
But then they have to attach the power of attorney along with the allonge, a copy of the POA.
Do they, JC?
You don't even need that. All you need to do is be on a call and agree with the other parties that they're allowed to sign that. Nobody's going to question the signature anyway.
Hey, before you guys do the IMF stuff, don't you kind of have to know? We were talking earlier, and Christian mentioned that he didn't care what they thought, on what they had on record because it was going to get cleansed anyways, which is true. But isn't it a good idea to try to get to know what their hand is first before you cleanse it?
Well,
so you see,
you're expressing who you are. You're tying yourself to the original trust, so you're standing as who you're supposed to be. So what they say at that point is irrelevant. You got to basically establish who you are. That's the point. What I want to get at, because if we're going to go into a div hearing and claim something, we got to be able to prove it.
And the way the proof thing goes is when we tie ourselves back to the original trust.
What do you mean? You want to prove that you're the grantor, you mean?
If you're saying you're the grantor of what?
Well, of the trust.
What trust?
The trust that you're working on.
No, you're correcting the record now. Remember now, you're correcting the record. They got you down as a trustee. So what trust are you talking about?
Well, the trust I'm talking about is if you're in a particular trust, if you're in a mortgage trust, and you're the grantor.
No.
Okay.
No. You're talking about the Declaration of Independence in order to correct the IMF.
We're talking about to correct the IMF.
Yeah, but you're correcting it because you want to be the grantor. You're thinking it's that you're going to be the grantor.
Right, but in order to express as the grantor, you have to accept the Declaration of Independence as your law form.
That's correct, and sign it.
And what if you wanted to only accept God as your law form? Then what would you do?
I don't know. We haven't gotten that far. We're just going to do the deal.
I'm that far.
Well, actually, it came up recently that the Declaration of Independence actually is those men really. I don't know how to say this properly. Can anybody chime in on this as far as the Declaration is consistent with Scripture?
What they declared before God, their right before God against the king.
That it's really like the declaration of Christ on earth, that same analogous to the Christ on earth.
But I mean, have you ever even looked up what the word Christ or the word God means?
It's a principle. I'm speaking of it in a principle.
I'm talking about a precept.
Okay.
Well, but part of the issue is that we still got to give these folks something they can recognize.
That's
right.
The point.
They're already recognizing international treaty.
Which one?
All of them.
What does that have to do?
It has something to do with thinking a little bit further than a piece of paper is God.
Okay, I've got the document here. If somebody wants it, they can pass it out to the rest of them. If somebody would give me their email, I'll send it to them.
You give the email right now. You want to collect emails right now?
Well,
Christian, you can send it. Christian, you can send it to JC, and I'll post it.
What's your email?
I sent that to you, I believe. I'll resend you one.
To which mailbox? send it to. Where am I at?
Yeah, you don't have to read it out loud.
Yeah. Where you want to post it?
Movingtiles@hotmail.com.
Okay, so if you're going to post it there, then we go there and get it.
Yeah, JC, would you send me one so I get your email address from there? Movingtiles@hotmail.com.
But that's your email.
Could you send that to learnlaw@comcast.net?
Where are you going to post it, JC?
That or Christian, if you're signed into Skype, you could just Skype it to me.
I'm not signed into Skype. Learn. Was that learnlaw.com? Chris?
All that's fine for you guys.
No, it's learnlaw@comcast.net.
That's great.
Is there a way to do that document? Is there a way to do that document without making a statement, to do it with questions?
Which document now?
The thing you guys are all going to do.
Well, I'm right now trying to figure out how to get it, because you guys are going to get it, but what about the rest of the folks? That's why I want to find out, where is this thing going to be posted so we can all go to one location and get the document?
Law learners.
You want to post? You going to post it on Law Learners?
Chris? Chris, did we lose you?
He's going to post it all on. He's going to post it on Law Learners. Don't worry. That's what he does.
I'm here.
Oh, Chris. There you are.
What was the question?
We were all wondering where you're going to post the doc.
Oh, I'll put it over on lawlearners.net.
Thank you. And
I'll put it under trust.
And Christian, what is the
Why
title
not
of
just
the doc?
unmoving titles?
What is
Well, it
the
can be
time
posted a couple places. I mean, there's why post it at one place? I'll post it at Law Learners under trust. That way, anybody that needs it that can't get somewhere else that it's supposed to be posted, it'll be posted over there at Law Learners for sure.
Okay, Christian, what's the title of the doc?
I'll post it tonight.
Okay.
What will you call the doc?
Treasury DIB and, what is the title? Yeah, Treasury DIBH and USAM 6-4.010 doc.
Can you say a little faster?
Treasury DIBH and USAM 6-4.010 doc.
Thank you, Christian.
USN 61577 what now?
That's 4010.
Christian, is there a way to do that document in such a way to word it where you word it as questions and rather than making a statement, so that they actually come up with what you wanted to say?
I don't think I have to be wording it with questions so much if I'm ordering or directing or commanding.
Okay.
Yeah, because the king orders.
Yeah.
Better.
This has been intense, fellas.
Lots of great information on the table tonight, that's for sure.
Yeah. You know, the East Coast fought after too.
It sure is. Yeah, you getting tired, Christian?
Yeah, my batteries ran out, so.
All right. Well, hopefully we can look forward to having another great conversation tomorrow night.
Okay, apparently this is not going through here. Do I have the email right, Chris? learnlaw@comcast.net?
Oh, Law Learner.
Yeah, that's exactly right. And as soon as you send it to me, I'll post it out. It takes about 10 minutes for it to get posted out where everybody can go get it.
Chris, you better confirm that.
He's not sure. He said the email wasn't working, Chris.
Yeah,
my email, learnlaw@comcast.net.
Spell it. LEARNEDLAW?
That's LEARN law, that's LAW, at Comcast.net.
Go.
Christian, I'll give you mine, and then we'll figure out a place to post it, and go from there if you want, at least.
I've got Skype too. Handy Summers is my Skype handle.
Yeah, Chris, I'll Skype it to you as soon as he emails it to me, if you want to do it that way.
Yeah,
if we can
that's
get me
fine.
good through. Christian, my email's ruleoftrust@gmail.
Hold on a minute. Rule of trust?
Correct.
Get out of here now. All right. Okay, rule 2, is that a number 2 or is that just T?
RULE of trust.
A rule of trust.
Just tell me when you hit the go button, and I'll check it.
Rule of trust at what again?
Gmail.
At Gmail. .com. Right. Okay, send it.
All right. I'll give it a moment and hope it'll come through. Hey, Chris, was it you that were so successful with the passport stuff?
Yeah. About World Service or United Nations of Turtle Island?
I don't know. I just have another Skype friend asking me if I could ask you with the passport your contact info. And,
just go ahead and have them contact me tomorrow.
Yeah, I'll share your Skype stuff with her.
Yeah,
your
that's fine.
Skype details, yeah.
Yeah, because I'm here all the time, a little bit like the rest of us in this group.
Got a Turtle Island passport?
Yeah, they've got them, but they're a little pricey. But the beauty about it, I had a chance to talk to Swift Arrow the other day, and what he told me, he says that they've already got the visa set up to where you can actually get a visa under United Nations of Turtle Island along with the passport. And I guess that was the tricky part, is getting the visa. He says it is a conditional visa. It's a visa to fly from the United States to the country of destination. He says that if you're looking to travel through other countries other than what the visa has been issued for, you have to get a humanitarian visa, which he says is not difficult, but he says that you would have to patch it if you were looking to do some travel in other countries other than what the visa showed on its face.
Oh, in other words, it's not a de jure passport, it's a de facto. Cover one.
I don't think that that's true. I know that Swift Arrow, he didn't bring that part up to me, but he would never buy into that stuff.
In other words, it's accepted on a case-by-case basis by other countries, in other words, what I'm trying to say.
Oh, here again, I don't know. You know, I've been helping Swift Arrow get this, the driver's licenses and the registration plates for cars up and running. And we finally have that up and running, and he's getting really busy. He had to open up a new building in order to accommodate all the businesses flowing in.
What is this, Turtle Island?
United Nations of Turtle Island.
United Nations
of Turtle Island.
There you go, Chris.
Okay, I heard it ding. Okay, is that...
I got it, Christian.
You get it?
Yeah, I got it. I just sent you an email telling you I got it, too.
Okay. Is that just one file there, or is it a combination of files?
Just one doc is what I got from him in the email.
Okay.
You're gonna post it someplace?
Yeah, it's going to be at lawlearners.net. It's going to have to give me about 15 minutes before I can post it out.
Not a problem.
Because I got to open up Law Learners.
In 15 minutes, I'll be asleep.
Boy, do I hear that.
Remember, that's all debt or credit that needs to be changed to account for trust. That's the problem.
On the allonge, we're going to be working together to try and get that wording right, as we were speaking about last night. Is that correct?
Are you talking about for the DOI?
Yes. For the Declaration of Independence. That's right. Yes.
Yeah, the allonge is just going to be assigned, as far as I know, and maybe Christian can clarify it, just a sheet that we're all going to do our signature. We're going to be signed. We're going to have somebody sign our signature by accommodation for us.
Yeah, I realize that, but what I'm saying as far as the wording is doing a sub-trust adding to the original trust. In other words, you know, adding to the Declaration of Independence. You know, accepting it for what it is and then adding to it. Because if we close out the account, it closes out everything. And thing is, as the masses aren't prepared for doing something like that. So in essence, we would have to set up a sub-trust to take care of those people that were going to be coming into play.
Well, I think Christian said a few minutes ago, let's just worry about doing it for ourselves first, and then we'll worry about everybody else.
Yeah, but if we close out the trust, it takes care of everybody else. Because
how do you figure?
Because decoration was for the entire planet. It wasn't just for individuals.
Well, I'm not arguing with you. I'm just trying to get clarification.
No, I'm not arguing either. I'm just saying
right.
It seems illogical to me because it's for, all men are created equal under the Creator. So it seems to me that we would have to somehow or another on the Allonge set up some type of sub-trust so other people coming into play that won't screw it up. In other words, once they get knowledge, so they don't end up being a debit creditor again, because that's going to in turn close it down the whole thing, and then we're all going to be underneath this crap again. Because
no. It's if we personally commingle our res is what gets us back under it. If somebody else commingles their res, they get back to being trustee. But if we don't commingle our res, then we'll remain grantor and beneficiary. Right, Christian?
Yeah, I believe that's the way it is, independently. Yeah.
Yeah, that's where some whole new this new trust technology would need to evolve to almost a programmable way, so that it would have saved things in there that wouldn't allow people in setting up their trust to do that. Safeguards where the software I'm imagining would show that there's where they're losing, where it's not happening in setting up their own individual trust and because if you have 12 people under you, they should all be trusts. In my vision of it, eventually that's what we would individually be working for, and in creating that model, there could be something that could perpetuate.
Okay, well, I'm getting tired, guys. I'm going to cut out, so if anybody wants to stay on the call, go ahead. It's going to remain open.
Christian, there's one quick thing I wanted to share with you, and it was another thing in the Florida statutes. I'm looking at my history in my internet browser right now to find it, but it went beyond Florida Rule 90.506 about some things about CCI.
Right. Mm-hmm.
And I just wanted to bounce it off you. I'm just taking a moment to see if I can find it, to see if not only if you're aware of it, but also if you think that it might comport for others on the call around the U.S. And I think I found it yesterday. No, it was probably the day before. Because yesterday would have actually been today, and it would have been the day before that.
Did you look under Rule of Civil Procedure 1.280 C7?
I just found it. It's in the Florida annotated statutes. And I'll take a note on what you just said, and we'll talk about that in a second. Florida what?
Florida 1.280 C7.
1.280 C7. And what is that?
That's rules of discovery.
Okay.
The CCI information and the trade secret information.
All right. Where I picked this up, I think it was off of the IACA website, and it's in Chapter 688. It's Florida Annotated Statutes, and it's the Uniform Trade Secrets Act.
Yeah. Mm-hmm.
Are you familiar with that in the Florida statutes?
Yep.
Okay. I'm just wondering if that's something we're going to wind up using in our pleadings in the future.
Well, that's tying in what I'm telling you under the 1280 rule.
Okay.
This is talking about trade secrets.
Okay.
So this is all state secret information, really.
Christian, that's been just posted. It's already posted out.
Okay. Yeah.
Thanks, Chris.
Yeah.
Thanks, Chris.
I have some information on which of the downloads have protective a protective order. You can find it in the downloads. Does anybody interested in knowing which ones those are?
Absolutely.
Yeah.
It was in the February 2nd. That would be a Q&A around an hour and 50 minutes.
You talking about the recordings with Christian, you mean?
Yeah.
Oh, okay.
Isn't that
Was it 120 or 150, did you say?
around 150. Talking with a gentleman started talking, the guy from Rochester was talking about he started it in protected trust. And I don't know if Christian went into it too much there. It doesn't look like he went into it. He was going more into... Okay, that's not... Okay, here we go. January 26th, yeah. January 26th, and that would be around... he emphasizes you need to put in a protective order on it. And that's closer to the beginning, so... that would be in the first hour. And then, I haven't got them all.
Let me interrupt you for just a second, just because I know Christian, if he's still with us.
Christian?
No, he went to bed.
Okay.
No, I'm here. I'm here yet.
I was just trying to tie in Chapter 688 and 1.280C7 about how we might use both of those things in our pleadings.
Okay.
Like, for example, are we going to be using those and those and those?
What?
What happened?
I think he had an electronic stutter.
Phone.
Is Chris from Law Learners on there?
Yeah, he is.
Can y'all hear me again? Can y'all hear me again?
When he says,
Yeah,
when he says he's...
Go ahead.
Yeah, when you say you're posting it, you say you're posting whatever you were posting. I mean, I sent whatever to Comcast.net. What do you get? Do you get something back or what?
Are you talking about sending something to my email?
That's what you said. You said you posted it on the email. So.
Oh, no. It's a website. It's lawlearners.net.
And that's not what you said. You said I posted it on lawlearners at Comcast.net.
Oh, well, excuse me. I'm sorry. Lawlearners.net.
Yeah, and it's impossible to get into. I mean, it's just really hard. I mean, you got this username, password thing, but it goes into other additions like add uppercase, add, numbers, add this, add that. Is there any easy way to get into this thing?
What I could do is I could just, are you on Skype?
No, I'm on the internet.
Well, I mean, I'm just trying to figure out a way of getting that information to you. If you are having problems getting into Law Learners, I can just send the information to you.
Yeah, I'm on Skype. I'm on both. Email, Skype, whatever's good for you.
Go to Handy Summers and say hello, and I'll piggyback the document to you.
Handy Summers?
Yep.
Okay.
Thanks, Chris.
Yeah, not a problem.
I was back to this Uniform Trade Secrets Act. I'm just wondering, are we going to be citing that as additional information in our protective order or our motions for protective order, or if you have any ideas as far as making our...
You certainly could, because that's setting up the trade secret information, the reason for the in-camera hearing.
Also, you want to avoid identity theft.
Okay. And outside Chapter 688 and Rule 1.280C7 and Rule 90.506, I hope I got that one right here in Florida, Can you think of anything else that we're going to want to incorporate into our statute sites?
Did you get the one copy that was from the O'Connors, which gave an example for the federal example for the protective order? The three docs.
I think
order and the response possibly by the opposing party.
I think I got that from you. Was it an example, or did it have any specific information on there?
Yeah, it was an actual motion right out of O'Connor's.
Do you know if anybody's name was on it where I would recognize it, or? I
forget who I sent it to.
Does it say just 06A.12 protective order? Take a look at that.
That's right. Protective order, yeah. And there were three documents in the series. One was the protective order motion, and the other one was the response to. So there were three docs there.
Yeah, one was a motion, one was a response, and one was a protective order. Yeah, actually, I've been reading those, all three of those, quite a bit this week.
Yeah.
Okay, so are we going to want to cut a lot of the information that's in there out, and just pick and choose what works for us?
Well, there's where the other fellow was talking about the benders was the more towards your locals if you're going in state-wise.
Right, I was going to go to the law library and get the one out of the benders.
Yeah, and see how that comported to what the elements were necessary to get that put through. That's just a federal guideline. You know, it may be different in your local states, so I don't know.
Well, I'm in Florida, so it'll be, if you have one for Florida, or if anybody is in Florida that's on the call that's done one, if you'd like to sanitize it and share it with us, that'd be great. If not, I'll go to the law library and get it for Florida and at least share that. And if I get that the information, I can share it with you, Christian, and then you can post it on the site, and that way we'll at least have Florida from benders, right?
Right.
Okay. And I certainly encourage anybody else to do that from their state. And between benders and O'Connor's, is there any other resources you can think of that we can access in order to build a really good protective order?
Yeah, you might want to try Federal Civil Rules Handbook.
Is that something we might be able to find on Google to look up, or is that a book we actually need to?
All library also then.
Okay.
That's Thompson West publication. That one is.
We found in the Ministry of Justice website in England, so I don't know if you've got like a Department of Justice website, and you may be able to find it there.
Morning, Pete.
Morning.
Is there a place that the O'Connor's example is posted someplace?
I have it. If you want to send me a Skype, I'll share that with you in a few minutes.
Okay, I've never done anything really on Skype. What?
Top of the morning to you, Pete.
You guys, thanks for all your resources and time tonight. Ma'am, if you want to send me an email, I'm at ruleoftrust@gmail.com, and just request that. I'll send it to you.
Thank you.
Yeah. Alrighty. I'm like Christian. I think I've hit the wall.
Yeah, me too. My eyes are getting fuzzy. Good night, guys.
All right, thanks for everything, guys. And ladies.
Yeah, for sure.